Okay, class, good afternoon. For those who want to turn on their microphone, I mean your cameras, please do so. We will start our discussion right now. Okay, so kumusta man mong tanan? We are having our live discussion via YouTube. So for others who will be watching this or who would be watching this, good afternoon to all of you, mga YouTube people. So today we will have our online discussion on the midterm coverage of our business law or obligations and contracts. I hope that you would all pay attention during our almost 2 hours. We will try our best to cover everything within 2 hours. So for those who have questions, you can raise them via our chat box or you can raise them by raising your hands. Siyempre, dapat naka-on cam ka mo. And then you would ask your question. So isa-isa lang dayon ang atong pag-asa question. So by the way, I would like to know how many are from nabay taga Bag-umon karon nga nag-apil? Or all from BSU Alubihid? BSU Bangon. Oh, very good, very good. So, from BSU Alubihid to A, pila ka buka mo? Can I see some of you? Just chat one. Kung Alubihid 2A mo. Chat one. 1, 2, 3, 2, 3, 4. Okay. 5, 6. So, na 2A. How about 2B? Chat 2. Chat 2 yan. 2. Okay. At least may 2B. At least na mo yung representatives ha. How about 2C? 2C. 4 sections magod mo. 3 sections from BSU Alubihid and 1 section from Baungan. So, I hope nga na 3. Na 3. That's 2C. 2C. Yes, at least na. At least na ano. So, medyo makampante-kampante na po. The reason why I am having this online discussion is for you to be able to understand the midterm coverage because as you can see, our midterm coverage is very long. Di ba? Nakita ninyo ang PDF? Nakita ninyo? Ang PDF. Ang PDF sa itong midterms, sa itong module. Ang uban magud kay wala silang module. Yes, very good. So, as you can see sa itong midterm coverage, taas-taas yun ni siya. So, ako na ning i-present ha, i-share sa inyo ang ato ang module. Maputi kataas. So, please bear with me. Please mute lang sa kay para kuan kay this is live ra ba. So, we go to our law on obligations and contracts. Can you see my presentation? This is the module, law on obligations and contracts. Yes? Okay, very good.
Yes, ma'am.
Okay, so I hope that you will stay good ha during our discussion kay I will be giving you some hints dayon sa ato ang midterms. Kay 8 pages ra ba tong midterms. So first is we have the general provisions. If you're going to look at the table of contents, we have here 3 chapters. Medyo taas-taas gini siya but don't worry, ayaw kay mo ka-stress kay gamay ra man natong i-discuss ani. So let's start first with the first article or section sa obligations and contracts, that is Article 1156. So, Article 1156 provides that an obligation is a juridical necessity to give, to do, or not to do. So, there are 3 things nga dapat inyong hunaon when we talk of obligation. That's to give, to do, not to do. I have already emphasized that during our prelim discussion. So sa ato ang juridical necessity, unsa man ni? When you say juridical necessity, this is the juridical tie. Ang tie nga atong ginahuna. That in case of non-compliance, there will be legal sanctions. So kani mga legal sanctions, i-discuss naman na siya later. So obligation is nothing more than duty of a person. Siyempre, kani siya nga duty is sa tao na siya. Dili na siya pwede sa mga hayop or sa mga bagay, mga computer, ana. Because only people like us, human beings, can do things, di ba? We can do things on our own volition. When you say volition, ato na siyang will. Kaya ang mga bagay, wala man sila will. Dapat na may magpalihok sa ila, di ba? Even sa mga hayop, man po na sila will. Even if kanang ganahan sila mo paak, lahi man po na siya. So, ang tawag ng tao, nga na duty, tawag na niya kay obligor. Ha? So the obligor has to satisfy a specific demandable claim of another person. So that another person is called as obligee. Ang uban na pronounce is obligee. Now, if this obligee, obligor, kung naani sila breach, kanang wala sila nituman sa ilang agreement, sa ilang obligation, then kanilahang mga gina-breach ng mga violations, enforceable ni siya sa mga korte. So when we talk of obligation, we also talk of damages. Why? Kay kung naamangog kay wala magud na himo, na kay na breach, na kay na violate, na ginay danyos. Mo na ginatawag na to danyos provisions. This is not the same as the damages nga naguba nimo isa ka butang. So damages would refer to sum of money. Sum of money given as a compensation for the injury or harm suffered by the obligee for the violation of his right. Nga na mo, ma'am. Ngano man nga obligee man ni. Nganong dili man kaning obligor. Kaya obligor, siya magod ang obligated to do something for the obligee. Now, there are two kinds of obligation. We have civil obligation and natural obligation. So when you talk of civil obligation, this is an obligation that if not fulfilled, kung dili mo ni mahimo yung civil obligation, this becomes due and demandable. And when it comes due and demandable, it can be enforced by our courts through action. Kaya dili man pwede nga naay violation. Like for example, na ako obligation sa imo. And then I did not do it. Now it becomes due and demandable. Musulti na lang dayon ko as an obligee. Hala, tuwara na sa korte. No. There must be an action on the part of the obligee nga madugid siya sa korte to enforce that right. So, kailangan mo file jug ka, dili po na pwede nga pasagdan lang po nimo nga mo ang korte, kaya ang korte kailangan mo doon po na sa mo, di ba dili? The other kind of obligation is natural obligation. Sa ngalan ng natural obligation, this is a special kind of obligation which but authorizes the retention sa voluntary payment of performance made by the debtor. And this is based on equity and natural law. So example ani, kung halimbawa, na kay duty to pay. So, ang obligor has to pay his dues to the obligee. Now, if the obligor cannot recover his payment, there's still prescription. So, sa ning prescription, ma'am, dili siya prescription anang mga resita sa doktor ha, na maguna prescription to pay, magud na siya. If maglapse magud na siya, so ibig sabihin, murag nag-prescribe na dili na kayo niyo maapas. But you have the obligation magud as a natural person to pay that person na imuang giutangan. Kay di ba sa ato class pag mangutang medyo naabdan na og 2 years. Unsa may kakahitabo be? Kung maabdan ng 2 years, 5 years, unsay ginahimo soban? Wala na to, tiway na to, di ba? That is not good. Dili na siya pwede nga tungod sa nakuan na, napasagdan na, kalimtan na. Kaya masulti dahil nga, wala naman good siya ni apas, ma'am. Na, may mamiga kita, pero wala man siya ni apas. Now, it doesn't mean that because that person, wala siya ni apas sa imo na dayo isulti nga natiway na akong utang. Kay kasagaran yun sa tong Pinoy, magtago-tago. Di ba? Magtago-tago, aron ingnon, ana, pwede na siya pwede. When you have this obligation to pay, you should pay. Dili na ka actually dapat ingnan. Now, interest, lahi po na siya nga topic. Ang interest, when you say interest, ato na lang ikuan ano. When you say interest, dapat nakastipulate yan. Kisa man sa inyo ang nagapautang or nangutang, dayon, gingnan lang dayon nga na interest. Kinsa man. Ang nangutang or nagpautang, diretso lang nga mag-assume na lang dayon nga interest. Actually, when we talk of interest, it must be stipulated in writing. Kaya kung wala gani na na-stipulate gani in writing, it's as if wala mo nag-agreean na. Ganun man. Ikasagara, when you make pautang ka, ang imo lang nga nagyapas is bayaran ang ako ma'am, tapos ako gina-interest. Pero that's stipulated in writing, Miss Agasita? In writing siya?
No, ma'am. Ako man ang nangutang.
Ikaw nangutang. Tapos, imo lang interesan.
Yes, ma'am.
Ano man? Para pautangon jud ka.
Mauna kong utang, ma'am. Hindi ko mag-interest.
Okay. So, that is your, murag nahulog na siya nga natural obligation sa imong part. Ha? That is already natural obligation kay wala man na siya sa balaod. It's more on equity. Mamay siya gisabot sa atong midterm coverage, di ba? Kaning ginatawag nga natural obligation. This is based on equity. Dili siya based on balaod. Because when we talk of balaod, dapat na yun na siya, nakastipulate na siya in writing. Because if interest is not stipulated in writing, it is as if it was not agreed upon by the parties. Okay. Ganun man, kailangan ko'y lain-lain klaseng interest na may, di ba ka ng straight, no? O napoy compounded interest. Ya, mas grabe yan ang compounded interest kaya kung di mo mabayaran, ang imong utang na interest, ang interest, gi-interestan pa dyan. O, mas ni-bloat na noon kay siya. So, una-una na lang ng 5-6 class. Di ba? Dahil kay tanan, no? Pero mo man ang ginahimo sa uban para magbayad dyan o makautang po. Now, let's proceed. Elements of obligation. Kanisha class, this is very important when we talk of obligation. The elements. Para mahibawan na to kung naabagyo'y obligasyon ng isa ka tao. The first is active subject. Sa ngalan nga active subject, this actually refers to the person who is demanding the performance of the obligation. And that person is called the creditor or obligee. So, kana siya class na iuban before nga kung ginatudluan, pag musulti sila active subject, masayop sila. Ilang ginusulti nga active subject, kato si debtor, dili. Kaya nganong nahimo naman siya active subject man si creditor nga. Kuan man, ang debtor man ang obligado, di ba? Siya ang obligado mahimo sa isa ka butang. But it is actually the creditor ang muapas. Siya ang muapas sa debtor. So, he is that person who demands the performance of the obligations. Mao na siya ang tawag na active subject. The second element of obligation is passive subject. Now, the passive subject, of course, is the one who is bound to perform the prestation. The prestation, ato na ni-discuss, no? Number 3 man siya. That person who is bound to perform, basta bound to perform the prestation or to fulfill the obligation or duty, that person is called the passive subject or the debtor or obligor. Bante obligor, pero actually obligor, no? And then we have the prestation. So many prestation. Prestation, tarungan na to ang spelling ha kay nauban kay musulti kay prestation. Prestation. This actually refers to the subject matter. The subject matter of obligation and the conduct required to be observed. To be observed by whom? The debtor. Ma'am, nganong dili man si kuan creditor? Kay mobalik lagi ta sa definition sa obligation. Kung musulti tag obligation unsa ganito, to give, to do, not to do. Now, kinsa man mohimo aning to give, to do, not to do, it is not the creditor, it is actually the debtor. So mao na siya, prestation refers to the conduct required to be observed by the debtor. To give, to do, not to do. Now, why is it nga not to give? Kaya dili man nimo ma-force ang isa ka tawo nga dili mo hatag. Mo lugar mana ka, ayaw lang ko hatagi. Ana lugar. No. Ang nalang gyud na kay na naman gud tay not to do. So mo na siya nga tulo ra gyud na siya class ha, dili ko ganan makita og not to give. There are only 3 prestations: to give, to do, or not to do. Now the fourth element of obligation is efficient cost. Unsa efficient cost? This actually refers to the juridical tie. Unsa naman po ng juridical tie, ma'am? This juridical tie is that thing which binds the person or the parties, the active subject and the passive subject to the obligation. Kaya nasa relasyon, nasa relasyon, o kanang ilang relasyon, mo nang ginatawag na to nga efficient cost of the obligation. So, mo na siya 4 elements. What are the 4 elements of obligation gani? Atong ko ano ni kay pangutana ta dali. What are the 4 elements of obligation? Dili ta mo tan-aw. Active APPE. Ha? Active subject, passive subject, prestation of efficient cost. Ana gyud na siya class ha? Passive subject, active subject, passive subject, prestation, efficient cost. Upat ka buka elements ha. If one is missing, then di ta makasulti nga that is an obligation. Now, prestation mo ni siya. To give, to do, not to do. Discuss naman ako ni before. So, injury, appeal gyapon ni siya gina-discuss when we talk of obligation. Injury refers to the wrongful act. Ang kaning dili maayo nga ginahimo Or omission, ang dili nimo paghimo, which causes loss or harm to another person. Injury yan. Now, damage, this is the result of injury. Kaya dili pwede nga si injury equivalent to damage. Si damage is the effect. Injury, mo na siyang kinasugdan na nagkaroon kayo ng damage. Okay? So, 1157. This obligation arises from the following, ha? Obligation arises from law, contracts, quasi-contracts, acts or omissions punished by law, which is actually delicts, delicts, and quasi-delicts. So, ang law, of course, this is imposed by law. Contracts, naagyon mo'y kasulatan, these two people, passive subject, active subject, they execute this contract wherein obligations are set in there. And then, na sila mga stipulations. Unsa man itong imong himuon, nga imong obligasyon, o ikaw creditor, unsa po ang imong duties. Tapos, there's meeting of minds, na sila agreement. For example, ani ka ng pautang, mamo gani usok class, contract of loan o employment contract. Then, we have quasi-contracts. Kani quasi-contracts, from the term quasi, nagsulti naman ko sa inyo before. When you say quasi, murag-murag. But actually, wala. Wala yung kontrata. Pero because of this kanang lawful, voluntary, unilateral acts na nahimo na nung enforceable. To the end, ang purpose yun ani nga na quasi-contracts. Okay? There must be no person who must be unjustly enriched or that person must not be unjustly benefited at the expense of another. So, natay ginatawag nga, example aning quasi-contracts, wa kabuk ni class, negotiarum gestio and solutio indebiti. Later, ma-discuss natin kaning negotiarum gestio magud class kay mamagod ni siya kanang pag-manage nimo sa isa ka butang nga dili imo nga wala kay authority. For example, ana kanang bitong nahugaw ang loan sa imuhang kanang imuhang silingan, di ba? Hugaw kay sa tanan. Actually, because ni sa example sa hugaw kay sa katanan ang bakuran or garden sa imong silingan. Dan ikaw, kay ganahan kay kastanan maglimpyo-limpyo, ningon ka nga, uy, lain magkistanaw sa tanin tanawin yahang yahang garden. Ako ning limpyuhan. So, di man nimo kaya nga ikaw lang maglimpyo, kaya ang yahamang garden jud no. Kay 2 hectares, 2 hectares yung garden. So, nag-hire dayon ka og mga gardeners, tapos nagkuan pag imo pag gyud gihimuan og kuan gipatsada gyud nimo nga gilimpyoan gyud nimo sa taman-taman pero wala ka na nang hid kay mo sila anto raman abroad. So imo lang pud atong tumong is para dili pod magkalat ang imuha ang katuoy magsanga-sanga na dayon itong mga vines niya tapos hadlok ka nga abdan pud ka og mga halas daw bi kay niabot ang tag-iya. Lipay kay siya clap hands din siya na siya wow limpyo na kaistanan akong 2 hectares nga garden. Siya. So, wala siya nagbali-bali nimo. Then imo din siya giduulan. Huy, silingan, ako'y naghimuana, nag-hire jud ko mga gardeners, mga specialista, nagkuan jud ko. Tas siya kay wala lang. Yarang isulti kay tiway. Ikaw, kay murag para sa imo, wala, nagtiway-tiway lang siya. Ang imo ang kana to is lumsa man na siya, wala man na siya nagbali-bali sa ako. So the question now is, kailangan ba bayaran si Miss Kumaradang nga naglimpyo-limpyo sa garden or dili? What you think? Kato siyang instance, kisay makatubag tagana ko upan. 2 points, char. 2 points. Ngano man Miss Kering and Miss Agasita? No, daghan kayo, la. Sige, ngano man dili.
Kay voluntary man ang iyang pagpalimpyo, ma'am.
Voluntary ang paglimpyo. Kisa pa naglain to ba?
No, ma'am.
No, si Miss Barcode, no po. Kinsa man ang mag-yes?
Wala siya gisugo man gud, ma'am.
Wala siya gisugo. So, kisa man ang mag-yes? Kisa mag-yes. Para maiba lang ako, ma'am, mag-yes na ako. The answer actually is yes. This is an example of negotiarum gestio. Sa ato mo naghalo, wait mo kay woman gisugo. But then actually, that person, for example, si Mr. So, natag-iya tong 2 hectares nga garden, although wala niya gisugo, si Miss Kumarada nga mulimpyo siyang garden, Pero sa ngalan nga nakabenepisyo siya, bayaran jud niya, di ba? Kay kung whether naa siya dito o wala, moabot man gyapon ang punto nga gyapon ng limpyuhan, so iya gyud nang bayaran gihapon si Miss Kumaradang. So as to how much, of course, sila nang sabutan kay kung mahal ra pud kaayo, na dili na pud na siya inataw ka kuan po justifiable nga nag-hire pa siya super duper gardeners. Ila na lang i-temper lang, depende na pud sa makaya po ni Mr. So. Pero ana gyud na siya class mo na nga sa ato kay although there was an unauthorized management of the property sa ngalan nga nakabenepisyo ikaw, so kailangan imo pud tong reimbursan kay paano katong nakagastos. Another case. Quasi kuan gyapon ni siya, quasi contract. Solusyo indemnity. So sa ngalan nga solusyo indemnity, unsa man ang word nga atong makita din habi nga bahalag dili ta mga Latino, Latina o dili ta gakuan og mga Latin. Indemnity. Pag musulto kag solusyo indemnity, naanay unjust enrichment. Okay, so I have an example. Mugawas gyapon ni sa exam. For example, Mr. Kumaradang na pod ha. Mr. Kumaradang, na-lay off siya sa iyang work. Okay? Na-lay off siya sa iyang work, and then, syempre, dagang kay siyang mga utang, dagang kay siyang bayron nun, depression mode siya, and then later, niya siya, I have to check my account. I'll go to my ATM. Dili na automatic tubig machine. I'll go to my ATM. Check my card kung napabay sulod or wala. So he went to the ATM, let's say BPI or BDO, no? Kuan ka na bitong we find ways. So dito siya dito sa kay BDO. Pag-check niya dito sa account, pin siya 6 digits. And when he checked his savings account, lo and behold, 3 million pesos. Lingi din siya sa siyang likod. Lokam, kidnap ko ani. Yan ay nakasulod. Unsa ni? Basin maamla ko ani. Pero wala din eh. So nakita niya ang 3 million. And then, nalipay kay siya. Yay! Nakoy 3 million. Though wala ko'y work because it's pandemic. I have 3 million pesos. Question. What should Mr. Kumaradang do? What you think? Wala may nakabalo. Nabutangan siya 3 million. What you think? Unsa yung dapat timon? What's the proper thing that he should do? Okay, I'll give 2 points. May nakuha ganina, no? I'll give 2 points to that person who will answer that question.
Report it to the bank, ma'am.
At ito, Miss Agasita?
I-report sa bank, ma'am.
What bank yung i-report? Di siya kabalo. Kaya ba, although kuha na, may bandera nga, ipang kuha, unsa nga bank? So niya pag-stress sa bank. What will Mr. Kumaradang do? Report it to the bank, tapos unsa niya pag-report sa bank? Ato siya sa bank. Ato siya sa police. Ato siya sa police. Kinapot siya sa police. Ato siya sa bank.
Yang state, ma'am, nga naay nakasulod nga worth 3 million sa iyang account.
Asa siya nga bank mo ato? Sa iyang bank? Or sa bank nga posible nga nagkuhan sa asa siya mo ato nga bank? Sa BPI? Mo ato siya sa BPI?
Sa BPI, ma'am.
BPI. Are you sure nga sa BPI? What if ang iyang bank kay kuan? Union Bank. Naki-check lang siya sa BPI.
I thought sa ma'am, kung asa siya kung asa siya nag-open sa iyang account, ma'am.
Okay, very good. So, Ms. Agasita will have 2 points. That is the correct answer. You have to report such incident to the bank, your bank, ha? Kung asa, bato siya sa iyang previous katipan. Bato siya sa iyang bank, ha? Kung asa siya na ay savings account. And then he has to report that incident so that mabalik nila, matrace nila kung asa to gikan nga kwarta, and then they can return it to the lawful owner. Now, that is called solusyo indemnity. So that person must not be unjustly enriched at the expense of another. No unjust enrichment. So kung halimbawa makita kag kwarta, di ba makita mo na sa mga nag-viral nga mga social, what do you call this, mga social ito nga, mga test nila, something, nga ilang ginahulog-hulog ang kwarta, and then they will check kung unsay reaction sa tao, ang uban, unsay ginahimo, ilang ginatago ang kwarta. That's not good, no? Dapat imo na i-return sa lawful owner ang katong nakita nimo. Same with the case of Mr. Kumaradang, nga nainisulod nga 3 million siyang account. Okay, very good. So next is delict. When you say delict, dili ning delict na delicious. Ang delict kay mga sala, omissions punishable by law. So obligations arising from civil liability, which is the consequence of a criminal offense, because in every criminal liability, naagyo kay civil liability. So unsa man tong civil liability? We have restitution, ibalik nimo, katong butang nga gikawat or nawa, reparation for the damage caused. Syempre, ang kanang musulti kag reparation, i-repair nimo, di ba? Indemnification. So kung dili nimo mabalik, di na po siya maayo, then imong bayaran na lang sa iyang kantidad. Mao na siya ang indemnification. So we have another quasi-delict, another source of kanang of when, where, or the source of obligation. So when you say quasi murag-murag na pod, this actually refers to torts. Saan ang torts, ma'am? Dili na torta, ha? Torts arising from damage caused to another through an act or omission, although there was no fault, ha? Walay sala, pero na-aksidente gyud nahitabo, nagyo-injury nahitabo, nagyo-damage. So, kani siya nga case, no contractual relation exists between the parties, ha? So pag torts, masama na siya, kanang bitang mga aksidente, or kanang bata, halimbawa, nga kuan kanang nakasala siya. Ya, dili man siya dili man siya of age. Pero yung parents, bahalag wala sila sala, sila ang mubayad ato sa pamilya nga nasad-an sa ilang anak. So mao na siya mga tortious acts, ha? Damage, wala kay intention to inflict injury or harm to another person. But because of that act or omission, na nahitabo na injury sa another person, magkaroon ka ng tortious act ana, so quasi-delict ang tawag ana. Mo na nga kay obligasyon. So if you look at these 5 sources of obligation, actually duha ra gyud ang pinaka-source gyud sa obligation. Nga naman, kay kini si kuan kani si contracts, no? Contract yun ni siya. Kaning tulo, si quasi-contracts, kini si delict, si quasi-delicts, these are actually imposed by law. Naani balaod jud nga naka-specify ngano kailangan jud na ay obligasyon aning mga tawhana nga nakasala or nakahimo injury or harm sa another person, even if there was no fault. Ana siya. So kani siya, ang isa is of course kaning law gyud, law, mga kuana sources of law. Sources of law kani siya si law mismo, si quasi-contract, si acts or omissions punished by law, and then quasi-delicts. Kani si contract, siya gyud nag-iisa, contract, ha? So we have 2 main sources of obligations, law and contracts. Under law, we have quasi-contracts, acts or omissions punished by law, etc., etc. Okay? So we have here Article 1158. Obligations from law are not presumed. Dili ka magbugna-mugna nga, ingon man sa balaod kay nagyo kay obligasyon. No. Obligations from law cannot be presumed only those expressly determined in the codes, civil code, or in special laws, syempre natin mga special penal laws, are demandable and shall be regulated by the precepts kung sa may nakasuwat sa balaod, which establishes them, and as to what has not been foreseen by the provisions of this code. So mao ginatong naon-naon ha, we have the civil code basihan sa atong mga obligasyon, o we have special laws. Then obligations arising from contracts have the force of law between the contracting parties. Nga naman, because these 2 people, they agreed among themselves that this is the contract with all the stipulations, the obligations of the parties. So mao na ilahang balaod, ma'am. Dili siya notarized. Sulti dayon. Pwede to nga because, for example, the contract of loan is not notarized, isulti na dayon nga wala na siya force and effect, ma'am. Tama ba yon? Dili siya notarized. Contract of loan, halimbawa, dili siya notarized. What do you think? Is it enforceable or not? Is it valid or void? Wala na ko na notaryohan, halimbawa. What you think?
Void siya.
Why? Why is it void?
Importante lang ang notaryo when it comes to contracts.
Are you sure? We will see, ha? Because pag musulti ta the validity of a thing, for example, in the case of contracts, dapat lang nakabutang dito ang elements. Absent what element, it cannot be contract, for example. So, contract, sama to, contractual relation of the parties, tapos katong object, and then of course, katong consequence nila ng But in that case, even if it's not notarized, as long as it is the agreement between the parties, o ilang i-affix dito ilang signature, that's the intention of the parties, that contract, even if it's not notarized, it is still valid and enforceable. Ang kuan lang yun, ana, kay naman na siya papel, no? Na siya papel. So, ang kuan na nimo, as long as these two people, because when you say contract, this refers to the meeting of minds between at least two persons, whereby one binds himself with respect to the other to give, to do something, to render some service, governed primarily by the agreement of the contracting parties. So, maurag yun niyo mo basihan, wala may nakasulat diri nga notarized siya dapat, no? So, there must be good faith. Good faith yun. Kaya dili po pwede na magmugna-mugna lang mo kontrata for the sake lang. Pag dili na gina siya ninyo inyong intention to come to an agreement, then wala na siya good faith. Kung wala'y good faith, then makasulti na dahil ka nga. That contract is not valid, it is void. Okay? So, next nakita ba akong presentation class o wala? Kita. Kita, very good. Okay. Very good. So, we'll proceed. Valid contract. Now, valid contract, it should not be against the law. Muna siya, it should not be against the law. Contrary. Mamusulti ka, ma'am, unsa gyud valid contract. So, these are the things that you have to check. Kung valid ba ang contract o di. It must not be against the law. For example, nagminyo-minyo mi sa akong uyab. Kinsa akong uyab kani? For example, akong uyab kay sa letter A. So, naminyo-minyo mi sa uyab. Ang purpose lang yun ato, kay para makakuha ko kwarta sa akong amahan nga 40 kadato. Okay. Purpose lang ako is para makuha ko kwarta sa akong papa nga 40 kadato. Kay isulti sa akong father, gang, you have to marry at the age of, butang na to, 21 pa ko class. You have to marry at the age of 21. Otherwise, wala kay makuha nga mana sa ako, which is equivalent to 10 billion pesos. Tapos na ako dollar account, tapos na ako mga properties dito sa Malibu, sa somewhere in Batanes, or somewhere in Timbuktu, whatever. Bermuda Triangle, ako tag-iya, na akong father. So ako, nangita na dahil ko, Kiki, kita kong lalaki, balag ko ganahan, uy, magbinyo-minyo ta, minyo ta. Hindi mo ta dirag po, married daw, married. Tapos kuha dito na may contract, of course, marriage contract. And then later, nag-execute me og among agreement na ang purpose ra gyud namo para magminyo kay para makuha nako ang akong kwarta din tagana og share katong lalaki. Gamay lang 10%. Tapos at kuan dayon pag mamatay na akong father palayo lang halimbawa, mamatay akong father ay patay naman di akong father. So, pag mamatay na akong father, as if wala namin nag-exist. So, what is that contract nga among gi-sign-signan? Is it valid or is it invalid or void? Agree lang mi nga after mamatay akong father, the following day pag mamatay sa akong father, di na mi minyo. Dili na mi minyo kay mo mong sabot lang nga makuha lang mi kwarta kanang amuhang ang kanang yahang inheritance mo orang purpose. So that contract actually is against public morals, ha? That's contrary to public morals, good customs, public policy, so that is void. In the eyes of the law, a void contract does not exist and no obligation will arise from it. So, dili pwede. Sa ngalan nga nagminyo-minyo ka mo, minyo jud mo. Ana. So, obligations arise as long as, of course, the essential requisites of marriage existing sa inyong case. So, obligations arising from contracts are primarily governed by stipulations. So, these stipulations, these are the agreements nga nakasuwat dito sa inyong kontrata o inyong giagrihan. Clauses, terms, and conditions of agreement. So, if a contract prestation is unconscionable, pag magsulti kag unconscionable, dili ka nang nagkonsyo-konsyo, dili siya fair or unreasonable, even if it does not violate morals, law, etc., it may not be enforced totally. So, pag musulti kang interpretation of contracts, this is actually a question of law. Maunsa na question of law? Muagi na ta din sa question of law nga muagi na gyud ta dito sa korte. Manuman, kay question of law is not equivalent to question of fact. Ang question of fact is kana lang nagkuan ba siya, niadto ba siya dito sa isa ka lugar, naa ba siya atong time nga ni-affix sa signature, question of fact. Question of law, unsa man ni siya, Civil Code, Article 1156 ba ang applicable ani? O mao na siyang question of law. Then we have compliance in good faith. Kani siya, when you say obligations of contracts, we should always check if naabay good faith. Is there a compliance in good faith sa mga parties? Because if there's no compliance in good faith, then questionable na ilang kontrata. Ha? So, it must be, kanang performance nila must be in accordance with the stipulation or terms of the contract or agreement. Kaya in the case atong duha ka bukataw nga uminyo-minyo, di ba? Unsa man to siya? Is it in accordance with the stipulations? Kaya syempre dito sa pikas nga contract, marriage contract, unsa nakasulat dito? Nga naminyo gid sila, di ba? Nga lawfully lang paminyo, then nag-execute na po sila of another contract. So, there must be compliance in good faith between the parties. Now, falsification of a valid contract. Masulti ka, falsified man ni siya. Only the unauthorized insertions will be disregarded. Okay, there are actually contracts na valid yun siya. On the face of the contract, valid yun siya. Pero usahay na yung mga insertions nga dili mao. Now, question. If, for example, na ay mga insertions, gipang suksok dito sa kontrata, kay sometimes Filipinos are very fond of just signing. Makita na nila ang first page, di na nila basahon tanan. Nya daw bikay naman na insertions. Na insertions dito. Oh. Nya na insertion dito nga gibutang dito nga ibaligya nimo appeal ang imuhang sakyanan. Mana ni ka? Mana naman insertion? Nya pirma-pirma ra ka. Remember, wala man kuan ni nagkuan sabot. So, imo ni siyang iskuan if ever na naman na siya parole evidence na dayon or naapa mo ilaing mga affidavit, mao na nga every time you sign a contract, you have to read everything bisag unsa pa nakabaga kay basin na kay ipang sign-signan dito, mga fine prints dito, nga wala ka ni agree. So, if that's the case, nga na mga unauthorized insertions, katong mga unauthorized insertions na dayon ang imo i-disregard. And the original terms and stipulations should be considered valid and subsisting unless kung katong insertion, konektado gyud kayo siya dito sa main portion jud sa inyong contract, then everything, the entire contract would be invalidated. Okay? Basta makastand gani ang contract, i-delete lang nimo tong mga insertions, padayon siya. Valid ang katong the rest. Ang i-delete lang ang katong mga unauthorized insertions. But if katong insertion, konektado gyud kayo siya dito sa main gyud sa contract, nga pag imutong tangtangon, mawala po ang main, then invalid yun ang contract. Article 1160 talks about quasi-contract. So, ano siya? Negotiorium gestio and solutio indebiti. So, when you say negotiorium gestio, this refers to the juridical relation which takes place when somebody voluntarily manages the property affairs of another without knowledge or consent of the other. So, that person shall reimburse the gestor. Ang kaning gestor, mo ni siya ang naghimo og katong for example, sa case nila Miss Kumaradang, it's Miss Kumaradang for the necessary and useful expenses incurred by the latter. Kaya katong ko paglimpyo-limpyo niya, importante maghihapon to. Kaya maglimpyo maghihapon siya. Di ba? Except, kung gibutangan niya dito mansion, lahi na po itong kaso. Well, ba, naglimpyo siya, then gibutangan niya mansion, nga porti kagwapa, then dili na siya gyud kailangan i-reimburse ni mong tanan unless si Mr. So yang gigamit ang katong mansion nga yang Airbnb yang giparintahan, syempre naka-benepisyo gid siya dako kay naka-income pa siya, then bayaran gyud niya yung reimbursean gyud si Ms. Kumaradang. So solutio indebiti, something is received when there's no right to demand. Mao to siya katong pag sulod sa account niya 3 million, that person, si Mr. Kumaradang, is obliged to return the money to the lawful owner. So he has to contact the bank para ma-return to o matrace mo kisa man lawful owner. So these are actually the civil obligations. Civil obligations, when we talk of direct criminal liability, we have restitution, reparation, and then indemnification. So na-discuss naman ako na siya earlier. Next, we have, now, by the way, the acquittal, for example, the accused was found not guilty on the ground of reasonable doubt. When you say reasonable doubt, medyo magduda-duda lang ka nga siya gyud ang sad-an. Pero naay may mga evidence, pieces of evidence nga makasuti ka nga nabay ako siya sa laata. For example, aksidente, no? aksidente ang driver, commit siya og aksidente na kay reckless driving siya pero wala gid siya intention to cause harm na. So it doesn't mean that because that driver was found dili gid siya inato gyud nga for example kanang nanay namatay ana wag gid to siya intention nga na but then dili na siya mag-prevent musulti man ka nga wala man ko na kuanan man good ma'am or attorney wala man ko na nakita nga guilty gyud sa akong pag-drive ato katong reckless imprudence resulting to homicide halimbawa dili man gyud ko na gyud ko nakita guilty kay giakwit gani ko kay gisulti nga uba gyud akong brakes or whatever nga it was beyond my control or unforeseeable to siya or because of some unforeseen events. So it doesn't mean that because he was acquitted, the accused was acquitted, dili na din siya pwede filean og civil case para makakuha dayon og danyos or damages ang katong family sa matay. Okay, lahi man gud ng reasonable doubt o kanag yung kuan kanag yung found guilty no beyond reasonable doubt. Kaya ang reasonable doubt nga gamay-gamay, no, gamay-gamay. Pero kung gusto tigil acquitted ang accused because there was no evidence that would point to such crime. No, wala gyud as in bisag usaw gid mo as in innocent gid siya gyud. So dili po siya ma-filean for accused. For example, persecution. Gikaso-kasuhan lang gyud siya for the sake. O dili po siya pwede nga ma-filean na din og civil damages. Wala may proof kay it was just for persecution purposes lang. Para lang yun, aron ingnon pasakan lang yun kaso. So, dili yun na pwede. Then we have chapter 2, nature and effect of obligations. So, we have here types of delivery, actual delivery, o constructive. Unsa ni actual delivery, ma'am? So, ang actual delivery is mismo, for example, this is the tissue. Sorry, class, kay lain akong ginhawa. So, for example, this is the tissue. Di-order na ko halimbawa sa SM, delivery. This is the tissue, gi-deliver gid mismo sa ako. So that is actual delivery. Actual delivery of the thing from the hand of the grantor to the hand of the grantee. Grantee ako, no, di ba? Or manifested by certain possessory acts. So for example, kanang royalty, makuha siya dito with the consent of the grantor. Actual yun nga delivery. Constructive, kanang symbolical lang siya. Kaya for example, when you talk of land, yuta, dili mo pwede the entire yuta ihatod jud sa imo no cannot be so title certificate of title or katong keys halimbawa sa balay ana mo na siya ang constructive nga tradition. We have kinds of fruits, we have natural, industrial, and civil. So when you say natural, naturalmente these refer to spontaneous products of the soil. Unsa tong soil kanang imo mag-umag ka or mag garden ka na kay product ana, so that's product of the soil, kanang imuhang baboy, imuhang kanding, nanganak, that's the young or products of the animals. Now, industrial refer to those fruits produced by lands of any cultivation of labor. For example, ana dito din ni turok lang dayon, no? Ni turok lang dayon dito sa imong yuta, imong ana ang imong yuta dito gipa tindog nimo. For example, kakita mo anang sa Cambodia bitaw class nga naghimo sila og for example, balay from yuta halimbawa, nagi labor involved or kanang balay niya na fruit nga extension, kana siya is industrial fruits yan. Civil actually refers to rent, kasagara gini siya. By virtue of juridical relation because there's a relation between the lessor and the tenant or kanang tag-rent. So, for example, ang example sa civil fruits kay rent. Then we have here determinating. I did not discuss this actually I would not be discussing this in full kay murag gamay ra tag oras plus wala man pud ako ni siya na-appeal sa midterms. Gilaktawan na ako ni siya class. So we have here accessions. When you say accessions, these are actually fruits of the thing or additions to the improvements upon the principal. So pag musulti kag accessions, nakagidagdag. For example, kanang mga anak kanang young sa animal accession yan. Na siya, fruit na siya. When you say accessory, for embellishment or better use, for example, ring. Nakoy ring. Tapos, nakoy diamante, akong gitaod dito sa akong ring, that's already for the embellishment of the prince of the latter. So, para matsyada siya, gitaod na ko na siya, that's accessory. So, for example, ikaw, nakay bag, and then sa imong bag, gikuanan nimo siya, gidagdagan nimo siya mga bululoy, matawag na accessories. Accessories. So next, we have here kung gikuanan nga na sa exam ha. Mura kani. Kinds of delay, Mora. We have ordinary delay and legal delay. So when you say ordinary delay, mere failure to perform an obligation at the appointed time. That is ordinary delay. For example, naamoy kasabutan, kay ikaw, limbawa, kisa diri ang gabaligya online. Kisa'y gabaligya online sa inyo. Mga seller.
Ikaw, ma'am.
Okay, very good, Miss Glendale Rao. Di ba, as an online seller, pag magkuan ka, kana online seller, wala magiging mo inatugin nga contract na magkita, jud, no? So, pag online, pag kuan na gani, mag-order na gani ang imuhang kliyente, musuti, musuti mo mine, or unsa man im order, ma'am, okay, what are the specs, then hatagan din mo siya price, di ba? So, pag kuan mo ana, musuti din na siya nga, i-deliver sa ako na siya, ma'am, mga 2 weeks from now. 2 weeks, mo na din ka, hala ka, ma'am, kuha na ba siya, pandemic, 3 weeks akong kailangan para ma-deliver gid na ako because of, for example, sa Manila to siya nimo i-deliver, so napakay-kuha na sa mga customs, whatever, dira nga mga conditions. So, so take 3 weeks. So, siya, okay, 3 weeks. And then, sa kuha na to pagka 3rd week, naibagyo. So, imo siyang gi-message, that day nga nagbagyo, nga ma'am, wala ra bay kuan, ma'am, dili makakuan, dili ma-ship kay naibagyo. Oh, there's storm ganyan sa imong area padulong. So, dili mo kuan dito ang courier, blah blah blah. Wala din siya, hala, ngano man, ana. So, kana siya, mere failure to perform an obligation at the appointed time. Ordinary delay yan. Now, halimbawa, ang isa na po ka-delay, ordinary delay siya at appointed time. Kani siya is legal delay ang isa. Default. When you say legal delay, mao na siya ang default. Ang uban magud kay nalangan lang og pila ka adlaw, so tinari kag default. No. Pag kanang default, this is tantamount to non-fulfillment of the obligation and arises after extrajudicial or judicial demand when was made upon the debtor. So kani siya, for example kato kay ordinary ra gito siya nga delay at an appointed time lang. Okay, at an appointed time. So ordinary delay lang siya. Ma'am, extend na to, ma'am, kay narabay bagyo. So siya, sige, kuan kaya nakani siya kuan. Okay, that's beyond your control man pud, no, bagyo niya. It's public knowledge, ana. Pero delay, legal delay, wala gyud. Wala gyud niya gi-fulfill ang iyang obligation to deliver. Ba, ikaw, wala gyud mo gi-deliver kay nana ka nga kabit man ito sa kumanghod. Halimbawa, kabit to sa kumanghod itong taga Manila nga nag-order. Hala, dili na ko to siya kuan deliveran. So, nanay default sa imong part. There was already non-fulfillment, no, of the obligation. And when you say legal delay, kanang in default na ikaw or in default na katong imuhang obligor, imong debtor, I mean. So, there are 3 kinds of delay. We have mora solvende, mora accipiende, and kuanit nyo klasang yang spelling. Mora solvendi, mora accipiende, and compensasyon more. So when you say mora solvendi, ang na-default ani ang debtor. So what are the requisites? Requisites of mora solvendi. Failure of the obligor to perform obligation on the date agreed upon by them. Demand by the creditor. Nagi-demand si creditor. Oy, deliver na. And then failure to comply such demand. So the effects would be the debtor would be liable for damages plus interest. And he is or she is liable for the loss of a thing due to a fortuitous event. Ano ka? Dabi? Kung ina na. Kaya dili man gid siya mo comply. Even if it was due to a fortuitous event, he has to comply gyapon. Maningkamot yun siya. Otherwise, he is also or she is also liable for the loss of the thing due. Ana siya. Kung excuse me, mora solvendi. Now, the other one is when there is default or delay on the part of the creditor. It's called mora accipiende. Ma'am, unsa ni siya? So, there's delay on the part of the creditor to accept performance of the obligation. Unsa man ni siya nga instance? Can someone give me an example of mora accipiende? Default on the part of the creditor. Can someone? I will give 2 points. Kinsa man, ang medyo malakas ang loob. Or are you sleeping? when you say aksipiende, for example, kanang creditor, no? Halimbawa, na may contract. The contract was for the debtor, that person, the passive subject, to deliver, halimbawa, a piece of furniture to the creditor. And then later, ang creditor, pag abot na dito kay creditor, for example, kanang Shopee. Shopee si passive, no? Si passive kuan na to si Shopee, creditor si Shopee, and then ikaw, dili. Si passive subject is katong isa ka tawo nga dapat mo hatag, no? Mo deliver mo himong performance. So, order ka dito sa kay Shopee halimbawa. So, pag order nimo, ikaw na to si creditor, musulti ka sa iyang, oy, nagbayad ko sa imo, I've already paid, so you have to bring me this particular furniture. And then later on, naka-decide ka, ikaw as the creditor na niya, you're the creditor na, ikaw na una ka, ay, dili na lang ko mupalit. Kay sayang man. Niabot na si Shopee. Nag-deliver na siya sa furniture. And then, masulti kag, hala, dili mo ko ganan ana, kay lahim mag-color. Pasumangi lang yung kagyud. Now, is that okay? Nga, musulti na lang dayon dito, ikaw, halimbawa, you would just say na, I will not accept that anymore because I changed my mind. Is that proper? The answer is no, it's not proper. So, there's already delay on the part of the creditor to accept the thing, no? The performance of the obligation. Or for example, kadungog mo aning, magkuha na lang ko, makichismis ako. Kanang natoy Jamil man siguro na siya. Jamil, do you know them, class? Kanina ko lang nabasa ito. Okay, lamon na. Yes, so nato siya. Yes, kabalog yun sila. So nato siya kanang graphics artist or katong murag mag-makeup mga artist ganon. Na ni atos nagsabot na sila, they already agreed to have this makeup something sa lang lugar kang Jamil. Tapos nag-travel pa ang katong makeup artist at yung crew for 5 hours ata from Rizal to the place of Jamil. Pero wala sila gibali-bali. Wala sila gibali-bali. Tapos tapos to'y graphics artist nga nagkuan siya kanabitang gingnan siya nga this is the design ana blah blah blah. Pero wala pod siya gi-honor ang yang design. So kato siya, there was more aksipiende. Gidili-delay gyud na ilagi default yun on the part of Jamil being the creditor. So the creditor would be liable for damages. And also, kung naaman to'y gipang deliver, for example, katong sa Shopee, he also bears the risk of loss of the thing. For example, kato ha, nag-order ko sa Shopee on COD, cash on delivery. And then ako'y nag-change ng akong mind. Nag-insist pag yung ka nga, dapat ganitong araw talaga dumating yun eh. Kasi kailangan ko sa graduation ng anak ko. Kasi yan ang gustong-gusto niya na furniture or fixture. Tapos syempre, katong passive subject, the one who performs the obligation. So, nisulti siya, sige po, i-deliver po namin. Tapos bigla, kamuluha, in transit, nagkuha ng katungihang furniture, nisulti din si creditor nga, ay wag na lang, kasi may mas mura pa pala. Pero in transit na siya, di ba? When you order online, for example, Shopee, makita man na nimo nga accepted siya, di ba? Accepted, tapos murag in transit na rin siya, na siya sa inaning nga lugar, ana-ana, tapos hindi ka nag-cancel, wala na ka nagbali-bali, and then later on, masulti ka, hala ka, dili na ko. So, nawala ang katong thing because of some fortuitous event. So, the creditor now, ikaw, would bear the risk of loss of the thing. So, moabot siya dito, halimbawa, hala, dili na ako, nagbayad ka. Nagbayad na lang dayon ka, for example, kato siya, COD yung isa, kani siya, nagbayad ka, through your credit card. So tika, ay, hindi na lang ko anak hindi na ko to dawaton. So, you bear the risk of loss na dayon of the thing. Kay, ikaw man, nagdili-dili man ka, na magkay-default gyapon, you would not accept the performance of the obligation because of change of mind. So, you bear the risk of loss. So, TY ka na lang. So, the debtor in this case will not be liable from the time that there was delay on the part of the creditor. So, wala na siya obligasyon na dayon sa creditor anang naitabuan. When the other one is compensation more when both are in default. So there's delay on the obligors in reciprocal obligation. So in effect ni kay ang creditor, debtor siya, then later si debtor naging creditor. Give me an example of that. Na si creditor, tapos si debtor, tapos later si debtor naging creditor. Ano sa na siya example? Actually natag na nako eh. Kana siya example sa Shopee, di ba? Shopee si maghimo sa performance katong seller, and then later pag mag-deliver na siya, si seller si debtor magiging na siya, magiging creditor na siya. Si seller siya na pud ang mag-demand og performance tax payment. So, when there's delay on the part of the parties, so there's the effect of compensating ang default of the other. For example, na ako'y nami contract nga gi-execute, buy and sell halimbawa, buy and sell. And then later, nakasala si seller kay sayop ang iyang gihatag nga product which is not specified in the contract. And then later, kanipod si buyer, kay nakasala pod siya, kay iya pong gibayad, di kulang-kulang pod. So there's default pod sa part nilang duha. So there's because of the default, both default sila, so their liability shall be offset by their default. So equitably ang ilang pag-offset sa ilang default. Kung unsa man ang ilang default, ma-equitably offset na siya. When you say offset, minus ang sala sa katong mga parties. So we have here kaning fraud, negligence, o kaning delay. Of course, delay na-discuss na nato. What are the two kinds of delay? We have two kinds of delay. Pas-pas lang. Yeah, just like in saying. Two kinds of delay. We have ordinary. Yes, miss. Miss yan, yes. Ordinary delay and
Legal delay.
legal delay. Okay, so ang legal delay ba, equivalent ba na siya sa ordinary delay or delay? Delay. Asa man between the ordinary delay and legal delay ang ginatawag na to nga default?
Legal delay.
Legal delay. Oh, very good. So, legal delay gina siya. So, pag musulti mo sa imong kauban, dili na ka musulti default, hoy, nag-legal delay ka. Social, ulbuyang kaspa. Legal delay ang tawag ana. So, we have here fraud, dolo. Then the other one is negligence. Mr. Lapad is here. Good afternoon, Mr. Lapad. Ayan, abi na kong nalapad po di mong camera. Okay. So, kuan siya fraud, we have dolo. So, when you say dolo, fraud, there is deliberate intentional evasion of the faithful fulfillment of an obligation. Mo na siya mga fraudulent people. Kaya nagyog ka intention to defraud. Ganahan jud ka kuan ka na mga scam bitaw. Oh. Then we have negligence. Negligence, culpa, ha? Culpa or fault. So kaning fault, culpa, negligence, this is voluntary act or omission of diligence. There being no malice, wala big ka intention. So the difference between fraud and culpa or dolo and culpa, dili lang sa spelling, but the other one, si dolo, na siya intention to defraud. Then intention to cause malice, the other one or to cause for harm or injury. Ang kaning si negligence, culpa, no intention to cause any injury, any harm, ha? So, ang kwala ni is lack of foresight ni siya or kuan ni siya kana bitong aksidente lang gyud, medyo tanga-tanga lang gamay, mao na siya nga ginatawag na siya negligence. Then we have delay, of course, nasulti na nako ni tardiness or default in the performance. Then we have contravention of the terms of the obligation, violatio. So, mana siya na violation of the terms and conditions stipulated in the obligation. And this must not be due to a fortuitous event because kung na fortuitous event, normally good, when there's fortuitous event, then walay violation on the part of the parties. Kaya dili man na, that's unforeseen. Dili na nila makita gyud unsa nang, for example, ay bagyo, ay baha, of course, dili na nimo ma-foresee, no? Kaya dili man punta si Nostradamus o dili ta mga propeta. So we have here for when we talk of performance of obligations nga naay sala, ha? Naay sala o walay sala, naay pagkatanga-tanga o nagpatardi-tardi, or naay violation. So we have fraud, negligence, delay, and then we have volatio, contravention of the terms of obligation. So we have here two kinds of fraud. Kaya istorya naman tag fraud. We have incidental fraud o causal fraud. Pag musulti kag incidental fraud, this is committed in the performance of obligation. So naa obligation, na-exist na siya because there's a contract, naghimo na ka og imong obligation. For example, nagkuha na ka, nag-execute mo contract, ang iyong contract is buy and sell, no? Nag-sell or contract of sale, contract of sale, ano yung isa is contract of sale, no? Contract of sale, na-sale. So, kato sa sale ninyo, ang purpose ato is, for example, Miss Jackie Lutumarong. Okay. Miss Jackie Lutumarong, good evening. Napadiay ka, mayo kay naka. So, we have here incidental fraud na contract or there's already an existing contract and then ma-execute na kamo, no? So, bigla, ma-execute na kamo. Pero before the execution, naa dito, naka-stipulate dito nga imong purpose lang day ngano na maligya ka kay daot gyud imong sakyanan. Daot gyud. So, ang imong kuan to kay daoton gyud nako ni siya kay para kuan kanang magkuon nako ang ligid. Kuon nako to ang ligid sa akong sakyanan. So, there's already incidental fraud. Causal fraud is kani siya is gi-execute, employed in the execution of the contract. So, sa pagka-contract pa lang, pag-execute pa lang sa contract, daot ang sakyanan, imong gibaligya. Ibaligya nimo kay daot ang sakyanan. Pero imong gipa-appear lang nga bag-o ang sakyanan. So, causal fraud siyang naitabo. Ang incidental fraud is, for example, nakuan kay may baligyan sakyanan, karanang sakyanan. Okay, sige, second hand. Pero imong gusto gyud ato kay tangtangan akong ligid. No. So there's already this performance of an obligation already existing because of a contract. So imo siyang gilin lang. Ang kuan gyud ani nilang duha is nagid sila panglilin lang. Fraud nga gihimo sa ilahang kauban sa party sa contract. So katong ilahang creditor. So nagid siya fraud. Incidental, unsa ni incidental gani class? Incidental and causal. Sa ngalan lang incidental after, causal during execution of the contract. Okay? Incidental after, causal during pag-execute sa contract. Ha? So maura gyud na siya tong balik-balikan. Then we go to kaning negligence versus ano na siya. 117 diligence, negligence. So diligence versus negligence. When you say diligence, attention and care required of a person in a given situation. And this is opposite of negligence. So, when you say diligence, gihatagan din mo og attention, pag-aruga. Ang isa ka butang. Mo na ang gina-require sa isa ka tao. So, for example, we have diligence of a good father of the family. Dili na siya nga, halangan kailangan man na siya diligence of a good father of the family. Ma'am, di mo ko father. No, you don't need to be a father to have this kind of diligence. For example, sa kanang kuani mo sa pag-atiman nimo sa for example sa inyong kasarang isa ka employer tapos biglang imuhang tao nakasala so din ka hala wala man ko isala anak ma'am okay dili man ako nagka-execute anak but question is did you actually perform such obligation which is the diligence of a good father of the family when you select that employee? Oh, imo bang nagtarong ba ka sa hiring and selection process ana imo employee kay basin gi-hire na nimo siya kay tungod sa sexy siya, blonde siya. So no, wala ka nagkuan na you were not diligent. You did not give full attention nor care in hiring and selecting your employees. Mo na nga katong imo employee nakasala na noon, nangawat na kawatan man di ay. Oh. So negligent siya. So when you say negligence, this consists in the omission of that diligence which is required by the nature of the particular obligation and corresponds with the circumstances of the persons of the time and of the place. Kaya kung muhimo man for example, you're a driver, ang driver sa sakyanan, especially if you're a professional driver, kailangan yun i-check yun mo ang brakes, i-check yun mo yung sakyanan, tanan-tanan, before ka mag-drive. Okay, what if, pag drive din mo dito, daot ang brakes. So kung daot ang brakes, of course, naagi na may tabog yun nga aksidente. Now, you cannot just feign ignorance to that. Ikabalo man ka nga, daot ang sakyanan. Di-drive gyapon ka. Oh, you were negligent. Mao na siya nga daghan jud tang madunggan na nga reckless imprudence, kanang reckless imprudence class, negligent na siya class ha. Reckless imprudence resulting to serious physical injuries, reckless imprudence resulting in homicide or in homicide. So mao na nun maka-cause na nun ka og injury or harm to other people or damage to property. So mao na siya ang difference between diligence and negligence. Now, sa transportation law, although we won't be discussing transportation law, kay later na siya if you proceed to law. Sa transportation law, sa common carriers, kabalo mo sa common carriers class, ang common carriers is kana siya public na mga transportation. So, jeep, taxi, kaning airplane, ana sila sa mga barko, kana sila na na sila mga common carriers kay public man na silang mga transportations. Ang common carriers, public transportation, the diligence required of them is not ordinary diligence. Ang ordinary diligence is diligence of a good father of the family. Ang kailangan aning mga common carriers kay extraordinary diligence. Katong extraordinary diligence, grabe gyud ang ilang ihatag yun nga attention and care to see to it that there won't be any accident that would happen while they're driving or transporting goods and persons from their destination, from their origin to the destination. Because, for example, sa bus, na nahitabong aksidente. Kaya siya, clear example na siya sa akong ma'am. Okay, once passenger siya sa bus. And then, for some reason, na-aksidente ang bus. And then, ang bus driver, nisulti siya nga, it was pure accident, wala ko'y sala, kay nauna sa ako nga sakyanan nga paspas. So, in order for me to avert that or to avoid the danger, yang giswerve sa right, niya naigo din siya dito sa semento. So, that was the reason why na katong mga nabiling nga mga passengers, namo sila. So, ingon niya, dili daw kailangan sila pasak kaso. Kay kuan daw kuno, kana bitawng di daw nila sala. So, ang kanang mga common carriers, mga bus, extraordinary diligence gyud ang gina-require. Now, when there's already accident, basta gani common carrier ikaw, basta na aksidente gani sa pasahero, especially pasahero, ang kuan gyud ana, ang fault gyud ana kay nagyud sa common carrier. Dili na kailangan i-prove sa korte kung nakasala ba gyud ang driver o wala. Sa ngalan nga na-aksidente ang pasahero, wala naabot siya ang destinasyon nga safe, then the common carrier is responsible. Okay? So, kailangan nyo sila magbayad yung tarong sa mga pasahero. Even those nga mga tao nga ilang na-aksidente. Okay? Wala man sila nakaabot safely sa ilang destination. Wala pag ang kanang pasahero kay nakikuha lang siya, nakisakay lang ba? Or discounted ang iyahang ticket. Sa ngalan nga wala siya nakaabot sa iyang destination nga safe, the common carrier, the bus, the public jeepney, public nga kanang airline, they are responsible. Okay? So dili na musulti sila dahil nga, ay, dili, danong tamo kaso. Kaya wala man po tayo pruweba, nga nakasala sila, dili. Okay? So we have here, kinds of diligence, muna na akong gisulti. Now, fortuitous event versus force majeure. Force majeure, no? Sama ko eh. This is force majeure class, ha? So, Article 1174, when you say fortuitous event, this is an occurrence or happening which could not be foreseen, or even if foreseen, this is inevitable, absolutely independent of human intervention, and this actually refers to the act of God. So, unsa man tong mga cannot be foreseen? Bagyo, baha, kana sila, dili na siya mga hinimo sa tao. So, fortuitous event na siya. The other one is force, F na siya klasa, force majeure. Kung masulti kang force majeure, this is an event caused by legitimate or illegitimate acts of persons other than the obligors. Except na itong obligor class. Kasi itong obligor, namina pa ka ni sila. So, when you say obligor, mabalik ta diri sa taas para makita gyud ninyo. So, the obligor is the debtor. Ha? Obligee is the creditor. Always remember that. So the obligor has no fault, but for some reason, naray ni nahitabo, like, asa man ta diri? Nay nahitabo gyud, which is beyond his control, beyond the acts of persons, then that event is known as force majeure. For example, kaning mga kuan, force majeure, for example, katong sa ISIS bitaw. Kada remember mo class katong sa Marawi siege. Sa Marawi siege, mga terorista man to no. So, ang katong mga terorista, dili to siya act of God. Of course, dili act of God, although they would claim nga para daw to sa mga Islam kuno. But that's not true. Ilaharag yun tong gusto gyud kay mga ISIS sila. So, katong mga illegitimate acts, si Mr. Briggs. So, katong mga illegitimate acts of persons, no? Other than the obligor. For example, kato siya during Marawi siege, natin mga bangko. So, mga bangko, may mga opisina, nakawatan sila, na. Now, the banks, for example, sa inyong tanaw, katong mga depositors atong mga banks, nawala man ilang kwarta. So, makademand lugar gid sila gid sa mga banks nga bayaran sila sa ilang mga deposits. Tanan sila. Do you think nga obliged yun ang bank para maghatag ato tanan sa ibalik sa ilang-ilang mga deposits? Narab man ang mga banks dito sa Marawi. What do you think? O tanan to si Mr. Briggs dili, si Mr. Jess Lapad. Yes, Mr. Lapad. I just saw your message. What is your answer, Mr. Jess Lapad? And I saw your 60 body. What is your answer? Do you think the banks are obliged to return the deposits of the depositors? Yes or no, and why? Kato sa Marawi stage to siya. What is your answer? Are they obliged, the banks, obliged to return the deposits of the depositors? Wala ka dungog si Mr. Lapad. Anyway, the answer to that question is no. Because the Marawi siege it can be deemed as a force majeure, no? Kato siyang naitabo. It was an event caused by the legitimate or illegitimate acts of persons other than the obligor. So the banks are actually the obligor. Kasi sila man to ang ginadepositohan atong mga kwarta sa mga depositors. Just imagine, class, for example, sa katong deposit, sa isa ka depositor, maabot og 2 million. And then, dili lang siya ang depositor. Ang bank, girampod sila, nawalan din sila ng pera. So, kato siya, if ang bangko, ibalik niya, as being the obligor, ibalik niya tong 2 million sa isa ka depositor, how much pagyud ang yang ibalik pagyud sa uban nga mga depositors? 3 million. Ang sa PDIC, pila raman ang kanang i-insure sa ila? Up to 500,000 raman. So, kulang-kulang. Manegative pa ang bangko. Di ba? So, kaning mga banks, especially mga commercial banks, mga private banks, they are actually existing. No, they were established not to be kanabitang maghatag, not to give dole out to the people. And they are not just there para lang ano, they are actually for profit. So, just imagine that. Kung ilalang, yes, Miss Agasita.
Hala ka mong Bobby kung ana day mga nakadeposit kag amount tapos na-rob ang bank so dili na dagan makag-after ang mga depositor mo?
Ang kwan yun na is, that's a good question. Ang kwan yun na is, naman na sila PDIC insurance. So, as much as possible, ang imuhag yung deposituhan sa imong banks, katong yung mga big banks, no? Kan mga commercial banks, sa big banks like mga land bank, development bank, BDO. Because, why? Nganong dili man tato sa mga gagmay? Dili man sa pag-ano ko sa mga gagmay nga banks, no? Kani mga dagko nga banks, pwede man sila maka-attach sa ilang name, dagko sila eh. Plus, ang kanang, for example, BDO naman to time nga narab ang BDO diri sa Cagayan de Oro. Nakadungog mo ato nga girab nya inang gisulti kay murag na internal agreement with somebody something it was an kanang nay mga bitaw mga internal people nga nag-grab whatever. So kana siya as long as kana siya nga bank manggod kay dako na siya nga bank mabalik na imong deposits. Pero manahi pa na sila sa adlong taas. I don't know with their process and their system, pero ilan na mabalik imong deposits. But dili nila mahatag diretso. Kaya pa man ang i-account ang tanang mga kuan nila, ilang mga deposits, napanay mga reserves nila, ilan ang tanawon. Pero kung dito ka sa mga gagmay-gagmay ng mga bangko, nagi probability dili mabalik nimo. Kay sila mismo naghihikahos din. Labanan na ka ng mga co-op banks bitaw. Mo na nga ikaw, if you really want to save, pero ma'am, naadya po sila makuha nga money, bisag nawala money. Naaman, pero madugay lagi. Kay ilan man tong kuanong garol-rol. Kay sa tanang mga bangko, unsa man ang mga bangko, na sa, I'm not a banking na kuha na, pero ang akong liban is kanang sa mga banks, for example, kana sila, under na sila sa supervision sa Bangko Sentral ng Pilipinas. So kana sila, ga-update na sila, tanan nilang mga transactions, under supervision na sila sa Bangko Sentral. Kung na sila yung mga inanamang good, i-check mo na siya kung naay negligence sa part sa bank. Kung walay negligence sa part sa bank, dako tayo problema. Kung naay negligence sa bank, then mabayaran jud ka in sigida. Ako ginaanan kay makabawi ka man. Pero katong for example katong Bangko Filipino, if you remember that no, bank. There was Bangko Filipino. Daghan jud atong natiway. Daghan jud sila ginatiway jud ato. So, if you really want to save, go save or open an account with big banks, katong mga commercial banks ng mga for how many years like BPI, BDO, of course kaning land bank, government bank man na, always na sila liquid. So dito gyud ka mag-deposit. Ayaw ka to sa mga gagmay because maglisod ta kay ang sa PDIC baya kay 500,000 na baya na. Imagine, pila ka book mo. That's the maximum na i-insure sa ila.
Yes, ma'am. Maximum ang sa land daw, ma'am, is 500,000.
Even sa land bank gani, maximum gina siya. Sa tanan na gina siya banks, maximum. So, as much as possible, mag-save yun mo. Or, ako ma-suggest, if ganahan yun mo, nga muda ko inyong kwarta, kay pila raman na ka% pod ang interest ana sa mga bank savings ninyo, i-invest siya. Pero as much as possible, kanang inyong pag-invest sa inyong money, dito po sa mga investments nga maayo pog return. Pag makadungog gani mo nga ang share, ang interest or profit is more than 3%, 5% bitaw kanang mga investment schemes, yes, dapat alam mo danang terms, yes. Para so that you'd be aware. So kana bitaw mga investments daghan na kay nakaroon naglipa na class kay especially it's pandemic. So ilang ginasulti, online ta, na inaani, networking, kana bitaw mga multi-level networking, that's a red flag. So ayaw gyud mong sulod ana, especially if that multi-level networking scheme, whatever, kay wala gyud sila products involved, or even if there are products involved, grabe na mga questionable nga mga products like mga pampadakog tutoy, pampaputi, ana, then mag-binary, sorry sa mga MLM, binary, diri butangan og tao, diri speakers, and then later diri speakers, then mag-pairing para mo dako imong kwarta. No, red flags ka na. So, ang mga investments nimo sa imong kwarta, dapat dito ka mag-invest sa mga products or services na sigurado ka o interesado ka. Because if you're not interested, pag business, when you say investment, business man na siya. If you're not interested, then mo fail yun na imong gi-investan. So, maura yun na akong masturya yun sa inyo. Mauna nga kamo, I know some of you are working, so your hard-earned money should be put to good use. So, aside from sa inyong savings, sa inyong family, kay actually class, no matter how small your income may be, as long as you know how to manage your budget, naagin mo yung savings. Have you heard of peso cents? Kana sa peso cents is naana sila ka na bitong gina-encourage bitong nga mag-save ka. So for every money that you'd receive, whether it's income or hinatag, nagyod kay part of that money that you have to save it. So imo na siya isulod sa imong alkansya, pwede na siya kanang inyong sudlanan sa mineral water, if you don't have alkansya kuan or whatever sa inyong sulod, then you won't mind at all. Okay. Usay magod sa banks manggod, pila ra man na siya ka percent? 7% maximum, di ba? And then if you
5% lang per annum?
yeah, 5%, uban kay 7%. And then ang uban pagid ana kay mawala pag yun. Kay natulog na pud kayo imong kwarta, wa nimo gidagdagan. So ang ilang gina-encourage gid na is you have to save. Now, co-op banks, mga cooperative banks, they're actually okay as long as you know the background of the co-op banks. Kaya ubang co-op banks manggo dili na to sila ka-sturdy. So unsa man tong mga co-op banks, mga dagko akong naibaw-an, we have FICO, tapos napod din. I'm not kuan ha, dili ko taga FICO, wala po ko'y kuan sa FICO, pero mauna ko nadungan FICO, and then before nag-OIC ako or integrated co-op, okay po sila. Tapos napoy kaning sa Miss Or co-op bank, o napod sila yun na. So just check the banks or the investment banks or financing nga inyo ang investan. so that your money, your hard-earned money won't go to waste. Ana gina siya kay dili na man necessary nga dato ka or maayo mo nga pamilya or dako gid mo mga family to be able to become successful sa imong life kay nama gyud na siya sa imuhang pag-manage gyud. Manage your time, especially you are students, you're working students for example. It doesn't mean that because you're working students, mapasagdan na ninyo inyong pag-eskwela. So it has something to do with management of your time, your resources. Kay lagi uban din ha class nga walang-wala. Pero bakit sila nagkuan yun, nag-triumph yun sila, na ningkamot yun sila tarong. So, it has something to do with management yun. Aragin na siya yun. Kwarta, oras, panahon, or oras sa imong family o sa imong kaugalingon. Okay, let's proceed. Requisites of fortuitous event. So, it must be independent of human will. Wala gyoy sa laani si obligor. It must be unforeseen or unavoidable. Okay, for example, katong sa terorista nga mga ISIS no sa Mauti. Mga Mauti to sila no, ang uban. So dito sa Marawi Siege, it was unavoidable po, unforeseen. And then of such characters to render it impossible for the obligor to comply with this obligation. Kaya imposible na sa banks to return all the deposits to the depositors. Impossible na kaya in a normal manner. And then the fourth requisite is the obligor should be free from any participation. Kaya naman ko uban, they would claim there were claims na uban nga mga banking personnel, bitaw, when they heard of the Marawi Siege, hinahinay daw sila kuot-kuot po. I don't know how true. So, as long as the obligor has no participation or that obligor did not aggravate the injury to the obligee, so there was no negligence, no imprudence, so he or she or they could not be found at fault. Okay, so wala sila sala. Exceptions, of course, are there exceptions when it is expressly stipulated that despite the fortuitous event, bahala pa na siya, bahala pag na fortuitous event, ang non-performance jud kay magiging due and demandable talaga siya. And then when the nature of the obligation requires the assumption of risk, for example, kanang mga products bitaw nga mga daot. Okay, natoy kas nga nag-order ko online and then I asked the seller kung katong yahang product madaot ba siya while in transit. Yang gisulti kay dili daw kuno, pero di ito kay nadaot, pero kapuyan naman po kung makikuan lalis niya. Nya kanto siya is nato siya assumption of risk. The moment that he told me na kato siya katong okay ang product. Ya pag abot diri pag-open, daot kayo. Bisag unsaon dyan ako, paningkamot dyan, nga maayo gito yung gatas, daot yun. So, naagid siya atoy, he was not actually exempt from this, from complying his obligation or performing his obligation. When the obligor is in delay, kapag kagani na nagani kay delay, whether it's ordinary or legal delay, basta na delay na ka, dili na ka maka-claim of fortuitous event. For example, kato siya kay katong isang case nato no nga nagsulti siya nga dapat ma-deliver siya 2 weeks or 3 weeks from now, and then pag abot ato sa 3rd week kay naay bagyo, and then later on musulti nan siya nga dili ko pwede nimo ma-find at fault kay tungod sa bagyo nya gi-demand siya nga mo deliver o kato siya dili siya makasulti nga fortuitous event man dili na ko kailangan mo deliver. No, dili pwede to. Then when the possessor is in bad faith or the thing is lost or deteriorated due to fortuitous event. So, for example, dugay lagi kay delay na gid siya, nadaot na lang ang produkto sa iya, then bahala pag na fortuitous event, dili siya makasulti nga exempt ko, wala ako isala. Then of course, the other one is when the obligor contributed to the loss of the thing. Siya mismo nakakos siya og pagkawala atong produkto na inyong gisabutan nga ma-deliver sa imo. So, he cannot feign ignorance to that, and he cannot claim fortuitous event to exempt him from performing his obligation. Okay? So, let's proceed. Dirita sa kaning dinakwa na sa loan, kaya wala na siya nakugyapil. You can actually read this class kay this module is very sabutable. You can understand this. It's just that the module is very long because of the coverage. Pero mamong yun siyang coverage mga good class when we talk of midterms sa obligations and contracts. Kaya taas yun siya. Taas yun siya. Anyway, if you perfect, you get perfect scores ani nga midterm exams, you will be exempted sa finals. Ako na, I assure you, you will be exempt from finals. And those, actually, wala po'y nakita nga nakakuha sa 5 gyud. Wala nila nakuha gyud ang 5 gyud nga gi-cover na to sa midterms. But even then, katong nag-submit, I will still give them points sa ilang final, sa ilang midterm nga scores, okay? So diri ta balik sa ato ang module. So chapter 3, excuse me. Chapter 3, this is on different kinds of obligations. So we have pure obligation and conditional na siyang obligation. So condition, what is condition? This is an event which is both future and certain, upon which the existence or extinguishment of an obligation is made to depend. So, na siya gihatag ni mga kondisyon. For example, ako, mag-deliver ko sa imo o furniture on the condition that kani siya nga furniture, kay ingon ani ang itsura ra nga akong mahatag nimo. Red lang yun. Dili ko pwede maghatag sa imong pink, dili ko pwede maghatag sa imong blue. Only red furniture. Tapos, kani siya is, i-deliver na ko 3 weeks from now. Dili pwede earlier. So, kato siya, nga stipulation, conditional to siya. Pure obligation, this is an obligation which does not contain any condition or term upon which the fulfillment is made to depend. So, this is immediately demandable by the creditors and the debtor. And the debtor, cannot be excused from not complying with this prestation. For example, sabot mo nga, kani siya kay i-deliver na ako ni nga furniture sa imo. Wala siya nagsutig date. Wala pa siya nagsutig kuan. Pero yung suti, nakita niya ang kuan. Nakita niya ang furniture. Balik na sa ako, be. Anak. So, sa inyo class, what you think? Kano sa to niya dapat i-deliver? Suti siya nga. Baligyan niya sa ako baligyan niya sa ako ang furniture, be. Then, suti ka, o sige. So, kano sa to niya i-deliver? Wala siya gisulti nga, de. Musulti ba ka dapat yun alam mo. Musulti yun, pwede pa ka musulti nga. Dili na lang nako to i-deliver ko, man siya kasultig date. The fact na nisulti siya, ibalik niya ni sa ako be, na nisulti ka ko, kana siya nga moment na nagsabot mo, i-deliver saya ang furniture. That's pure obligation. Walay date, walay other mga conditions. Pure obligation siya. So when you say conditional obligation, this is an obligation which is subject to a condition. So we have two kinds na condition ha. We have suspensive and resolutory. So when you say suspensive, sa ngalan nga suspensive, ha? Suspendido. Its fulfillment gives rise to an obligation. And the demandability of the obligation or the effectivity of the contract can take place only after the condition has been fulfilled. Resolutory obligation, its happening extinguishes the obligation which is already existing. So, tagaay daw ko, example daw aning suspensive obligation o resolutory obligation. Tagaan ako 5 points sa midterm. Suspensive. Ang isa is resolutory. Kisa man ang isog-isog ninyo. See, say isog-isog. Isa-isog ninyo, class. Isa-isog ninyo. Wala. Wala siya. Wala, class. Kaya, when you say suspensive, again ha, when you say suspensive, fulfillment gives rise to an obligation. Resolutory, happening, extinguishes the obligation. So, ang pagmusuti ka suspensive, pag hitabo sa kondisyon, saka pa ka obligado. For example, kondisyon sa akong papa, ani. Anong papa man yun nga? Wala na akong papa. Sige lang, mama na lang. So, ang kondisyon sa akong mama kay nani, na siya nga, Han, tagaan ka og 2 million pesos pag manganak na ka. Is that suspensive na kondisyon nga ang gibutang or resolutory condition? Katong maghatag ko sa imo og 2 million pag manganak na ka. Is it suspensive or resolutory? Kana siya class. Tagaan ti kag 2 million pag manganak na ka. So kana siya nga example is actually suspensive. Saka pa mahitabo ang iyang obligasyon pag manganak nako. The happening of the condition actually is that reckoning point when the obligation starts to run. So pag manganak nako, pwede na ko mag-demand sa kong mama nga mabayari ko og 2 million kay nanganak nako. But pag mosulti siya, imuha ning akong balay until mamatay ko. Kana. Sulti imong mama. Imuha ning balay, himua tanan, dinhi sa akong balay until mamatay ko. So, ang condition dito is pag mamatay ang mother, na pa ang katong pag ayom-ayom nimo siyang balay, paggamit sa balay. Once mamatay na imong mother, lay na po na ko na ipatay-patay, no? Once mamatay na si mother, then ma-stop na ang katong yang obligasyon nga ipahulam or ipagamit ang iyang balay. So that's the difference between resolutory and suspensive obligation. So suspensive fulfillment gives rise to an obligation. So pag mahitabo na ang panganak, start na si obligation. Ang sa kanang isa, resolutory obligation, padayon ka sa pagtamasa or something, tapos bigla naabot si condition, stop. So, it's happening extinguishes the obligation, which is already existing. Okay? So, we have here Article 1180, so period. So, period, dili na siya period nga mens, ha? Period is a future and certain event upon the arrival of which the obligation subject to it either arises or is extinguished. So, pag musulti kag period, kani siya, pag musulti kag period, when his means permit him to do so, little by little, as soon as possible, partial, as soon as. So, kani siya, future, ha? Future or certain event. For example, karon nag-online discussion ta. This is actually before, days ago, this is just a certain event, future event, period, no? Upon the arrival of which. So the obligation is subject to it. So, karon siya, atong period nga mag-online discussion ta. Ha? So, mao na siya atong that time, future or certain, basta sa tikag period, it's future, time, or certain event, arrival of which mag-arise ang isa ka obligation or ma-extinguish, mapalong, mawala ang isa ka obligasyon. Same with kato atong example, no? Katong period ato is time nga mga anak, no? Period, anak, time mga anak, anak siya. Time mga anak, ano sa June. Nanganak ako, June, period. Or certain event, kato pagpahanak, anak. Mao to siya ang kato sa period. Condition is, ang kondisyon niya, unsaon to siya. For example, kani siya, sa condition, sorry class. So, yung say condition, event, future uncertain. Future uncertain event. Kani si period is future man ni siya, time ni siya, has something to do with time. Future or time, certain time ni siya. Then we have here Article 1181, suspensive conditions. So, mao na siya, pare-parehas na sila class. And then we have here the three kinds of conditions. We have potestative, casual, and mixed. So potestative, suspensive condition, which depends upon the will. Isa ra ka contracting party ang naay right ani. Kanang siya ang naay will gyud ani gyud ang kasagara gyud ani kay kaning isa ra gyud sa party, isa ra gyud sa contracting parties because we have two parties man involved, di ba? We have the debtor and the creditor. So if it is actually the sole will of the debtor, it is void. If it is the creditor, it is valid. Ngano man ma'am, nga ang kanang will dapat sa creditor, kaning potestative nga kondisyon, no? Ngano sa creditor? Because again, the creditor is our active subject. If the will is left only at the sole will of the debtor, dili na siya pwede kay lugar. Musulti na lang si debtor nga, ako ni siyang himuon sa akong gusto lang nga panahon. Ako'y magbuot. No, cannot be. Because he is or she is the passive actor or subject. The active subject is the creditor. That's why dapat ang katong will naa sa iya. This is to prevent the establishment of illusory obligations. Kanang mugna sa imurang utok anang obligations. The second kind is called casual. When you say casual, the condition depends upon chance or the will of a third person. For example, kaning cellphone warranty, ha? So dili man na siya nga kana bitong nakadepende na siya sa kang debtor o kang creditor. Kaya naging na third party. Kaya naman na, for example, kanang mga cellphone. For example, maligi akong cellphone. Dili man na siya nga ako lang maka-warrant, ana. Dili man ako makasulti nga, okay, ako na siyang ayuson. For example, Samsung. Na. Kaya dili man ako tig-ayog yun. So, there must be a third person na makagaranti, ana, makahatag ng warranty. Next is mixed. The condition depends partly upon the will of the parties and partly upon chance. Wala siya ang sa mixed na condition. So, kato silang creditor, plus, for example, kaning tigwaran, halimbawa. So, there's mixed nga condition ani sa ato ang topic. So, next is we have here impossible conditions. Two kinds of impossible conditions. We have physically impossible and legally impossible. When you say physically impossible, dili gyud siya pwede by its nature mahitabo or mo-exist. Impossible gayud. And then we have legally impossible. This is actually contrary to law, code, customs, or public policy. So, unsa man na for example sa legally impossible, ma'am. For example, kanang ang pagkuani mo nga palayo lang plasa. Kanang bitaw mosulti ka dito nga di mo ko maka. For example, kanang bitaw burusan nimo ang imong kuan, ang imong ang pinsan sa imuha. For example, ikaw. For example, ako lalaki ko, and then bigla ang inyong agreement kay burusan nimo nako ang katong inaanak nako para magkakwarta ako. Bawal yun. Physically impossible, dili gyud siya pwede mo exist. For example, by its very nature, for example, ang lalaki burusan nimo, dili man pwede maburus ang lalaki, di ba? So that's physically impossible. So we have here Article 1184. We have positive condition and negative condition. So when you say positive condition, this refers to the fulfillment of an event or performance of an act. Negative, non-fulfillment. So positive condition, fulfillment. Negative condition, non-fulfillment. Maura gina inyong balik-balikon class. So time is the condition which would happen for the obligation to extinguish. Mani siya ilagi ko sa time. So mato dito sa katong akong gikuanan class nga na ako'y kuan diri kanisiya. Rights of the creditor, kanisya, fulfillment of the condition, debtor without fault, with fault. So, ako ni siyang ikuan sa inyo class ang kaning isa pa ka kuan class ha kaning sa midterm na gyud natong exam. Wa na tay time, hurot na kong time. Nakoy password. Nakoy password. So, okay. Naapa ba mo? Gising pa ba kayo class?
Yes, ma'am.
Yes, ma'am.
Gising pa kayo at dito na tayo sa ating inyong ginaabangan. Ato ang midterm exam.
Wow.
Okay, midterm exam. No, ni itsura sa inyong midterms class. 8 pages kayo class. Kinsa man tong ganan mo answer. I will not give you the exact answer class ha. Just to give you this. Para at least makadiscuss mo na. After we will have this online discussion, I would suggest that you would group among yourselves and discuss this. I want all of you to have perfect scores so that you will no longer take the final exams. Now, as you can see, we have here multiple choice questions and of course essay. So, ang essay tarungag yun ang yung in English san, mubo lang akong kailangan. I want you to construct very good sentences. Mo na nga, I'm showing you this. Sumusod din ako ni ipakita, pero sige na, ipakita naman ako sa inyo. So, we have here activity 1. Number 1, kita mo class? Kita mo, ni?
Yes, ma'am.
Actually,
Yes, ma'am.
nay nag-request man god nga lain nga satellite school. Tapos nag-request silang module. Hindi ko alam bakit hindi sila nakakagawa ng module, no? Nag-request sila sa kuno sa ako module ganun. So I just gave Sir Matt na lang. Dahan sig na nga. Sige, as long as i-retain akong name, Because tanggalon akong name, na sila one infringement. And then for this exam, kani siya, ako, wala na ako nagihatag sa ila. Okay, para ra yun sa inyo. So we have here activity 1, number 1, Belinda filed for support against Bentong, the biological father of her daughter, Selena. Bentong alleged that he cannot be forced to support Selena because there is still no decision on the rape case Belinda filed against him. So in this case, si Bentong, gifailan siya og kaso ni Belinda, nga gi-rape niya si Belinda. Now previously, in the DNA test conducted, there was a finding that Selena and Bentong's DNA match. So ang bata o ang papa nagmatch ilang DNA. So when you say DNA gani nga nagmatch, ibig sabihin kay 100% na match sila paternity testing. So si Bentong yun father ni Selena. So now, question, can Belinda still pursue the civil case against Bentong? Why? So we have here the choices. A, B, C, D. You choose which among these choices is the correct answer. Akong basaw na. Letter A. Yes, Bentong and Selena look the same based on the DNA test conducted. Bentong cannot feign ignorance result of the DNA test. Letter B. No, there must be proof beyond reasonable doubt that Bentong is the father of Selena. There was no judgment yet if indeed Belina was raped by Bentong. Mao man guni allegation ni Bentong. Wala pa man ko na found guilty gyud or napasakan gyud og kaso sa rape case. Is that the correct answer? Letter C. No, there was no civil case filed against Bentong yet. There must be a civil case filed before the court before he will be forced to support Selena. Kay diri based sa facts, kapag ka mag-answer mo class, you look at the facts of the case. Ang gisulti lang diri, si Belinda nag-file siya support against Bentong. Filed for support against Bentong. So what do we mean by filed for support? Nana ba siya gi-file? Nana ba civil case? O wala? So it's up to you to answer that. Letter D, yes, the DNA test conducted between Bentong and Selena matched, and there's no doubt that Bentong is the father of Selena. Bentong, as a natural and biological father of Selena, has the civil obligation to support Selena, and this should be fulfilled by him. This may be enforced in court through action if not fulfilled when it becomes due and demandable. So you choose which among the choices is the correct answer. Okay? So now may time to discuss among yourselves that after the online discussion. Number 2. So true or false? Criminal act does not necessarily give rise to civil liability. Is it true or false? Then you choose among the choices we have here. True, true, false, false, but we have this statement. Tarang wala niyo ni class sa tanaw lang. Then number 3, true or false? There's no pre-existing contract in, again quasi-delict. No pre-existing contract in quasi-delict. Is it true or false? Letter A, false. There is no contract under natural obligation in quasi-delict. Letter B, true. There's no pre-existing contract in quasi-delict. True or false? Tanaw mo ha. What do we mean by pre-existing? Or what do we mean by quasi-delict? Nasa inyo. Nasa module. Number 4. This happens when the creditor makes a demand and the obligor fails to deliver the thing. Ako na na-discuss ganina. Letter A, is it negligence? Letter B, is it mora solvende? Letter C, mora accipiende? Letter D, compensatio morae? Letter E, compensatio mora. So which is the correct answer? Number 5. It is don't worry ha, kay this is live class, so you can still watch this later. Number 5. It is a mode of extinguishing obligations whereby the right of subrogation, nani siya actually sa kuan class, nani siya sa module. Right of subrogation, meaning to say, imong i-subrogate im kaugalingon, may occur. Is it novation, compensation, payment, condemnation, confusion, or compromise? Choose among the choices. Select. Number 6. It is an obligation to give a parcel of land subject to suspensive condition. Who is entitled to the fruits that accrued during the pendency of the condition once the condition is fulfilled? A. The buyer has the right to fruits. B. Seller has the right to fruits. Kani siya suspensive condition man sa class. Akong di-discuss sa inyo unsay suspensive condition. And then, napo ni siya sa module, you will just relate. Kang kinsa mahatag ang fruits during the pendency of the condition. While napatong condition, okay, suspensive man siya. What do you mean by suspensive? Sa kara mahitabo ang obligation sa pag-abot sa condition. So, always think, suspensive condition man siya, tapos ang fruits during pendency, na by obligation ato o wala. So, you have to check and then select which among the choices is the proper answer, is the correct answer. A, buyer has the right to fruits. B, seller has the right to fruits. C, buyer and seller will receive the fruits pro rata. Pag musulti kag pro rata, hati sila. Or kung unsa man tong fruits nga naa atong pendency, si buyer ba to or si seller, then after pag-arise na sa condition, si buyer ba gihapon or si seller, that is pro rata man to siya. Letter D, buyer will receive the fruits since he is the active subject. So, you check ha. Tanawa gini yung mga class kaning ilhang mga choices. Number 7, is any event which cannot be foreseen or which though foreseen is inevitable. So, what is that answer? Civil disobedience, negligence, fortuitous event, or force majeure. Pili lang mo, na-discuss na ganina. So, 8 to 10, this is actually kuha siya ka ng medyo taas-taas gamay, no? So, Aling Choling sold a parcel of land to Joy for 240,000, which is payable in installment of 20,000 a year. Yan. The land was delivered to Elena, who obtained ownership thereof. After Elena paid 200,000, she could no longer continue paying since she could not go outside of their house for fear of being infected with COVID-19. But she was willing to pay 40,000 through bank transfer if she was given more time. So, di ba, nakabayad na siya 200,000. Ang yung dapat bayaron is 240,000. Katong yan na lang nabilin is kanang 40,000, di ba? Pero isulti dili kay 20,000 per year. So, katong equal na net kay 2 years ni siya maximum, no? 2 years maximum kay 20,000 per year, ma'am. Through bank transfer if she was given more time since she is waiting for her sister's financial assistance to be wired from abroad. Question. Dili na talapit ha. For failure to pay the balance on the agreed date, Aling Choling filed a case against Elena rescinding the conditional sale invoking 1191. So, decide. A, rescission. Pag musulti kag rescission is canceled na. Canceled ng contract. A, rescission is not the proper remedy. Kaya ang gisulti ni Aling Choling filed the case against Elena rescinding. Ibig sabihin kaya nang murag mana na, stop na, ha? Stop na. So dili po niya makuha pod ang yuta. Yun, na dili matransfer sa iyang title. A, rescission is not the proper remedy. Aling Choling should have amicably settled with Elena since COVID-19 is already a pandemic. B, rescission is the proper remedy. Bali, ang gisulti sa letter B is, okay ra, dili na to ipadayon kay wa man gyud niya na tuman. Wala na tuman ni Elena being the debtor ang pagbayad. So dapat wala na sila kontrata, dili na pod mapaiya pod ang yuta. Regardless of Elena's reason, the fact remains that she defaulted in payment. That is B. Letter C. Rescission is not the proper remedy. Novation is the proper remedy to be fair to both parties. Ang novation is baguhon nimo ang contract. May bago nga contract. In lieu of the first contract, kay pag musulti kang novation, dili na kay di ba naman 'to pandemic. So katong pandemic, another condition na siya para i-change ba ang contract nga dili na lang to mao ang dapat nga contract katong previous, katong ilang terms nga 240,000, 20,000 per year. Novation ba? Kaya novation man na siya is i-change nimo ang contract. Magiging bago na siya. Or D, condonation is the primary remedy, not rescission. Ang condonation mo dito is TY. Mawala na lang to, tangtangon na lang siya, total kuan man po pandemic. That is condonation. Condone ba? So which among the choices is the correct answer? Rescission, not rescission, kanisya novation, or condonation? You choose. Discuss among yourselves. 11. If the thing to be delivered is lost due to the debtor's fault, which of the following is or are the debtor's obligations? Letter A. Debtor shall pay the price of the thing lost only. Half money siya, kanibitaw na lost. I mean, the thing delivered was lost. Ang naisala si debtor. Debtor, it was the fault of the debtor. Di ba sa itong gisulti na to? As long as walay dasala si obligor. Which of the following is or are the debtor's obligations? A. Debtor shall pay the price of the thing lost only. Kaya nga naman class, nga naman only naman good to siya damages, di ba? pag makita ka nga nakasala gyud ka na damages, so asa man ni mobayad ba siya, kailangan ba siya nga magbayad og damages or dili, or katulang price lang sa thing. So i-check nyo balik sa katong discussion na to. B, the debtor shall pay the price of the thing plus interest that could have been recovered by the creditor or buyer. C, the debtor shall restitute. So yung ibalik katong nawala kay lost man, no? Yang ibalik katong thing that was lost. Or D, the debtor shall pay damages incurred and the price of the thing lost. Imagine, lost due to the debtor's fault. Sa dira class, A, B, C, or D. Then number 12. Okay pa mo class? Kuha ninyo niya, tanawan ninyo ni Unya. Number 12. Ben was depressed this past few days. Mo ni akong isulti kanina class, he was one of those employees laid off due to the repercussions of the pandemic. He still have a lot of bills to pay and had to pay for his house and lot and car, which are under mortgage. He later decided to check his savings account near the BPI ATM, and he was shocked to see that 4 million pesos was deposited to his account. He could not believe that such amount could be deposited to his account. He wanted to know who did it, but thought it must be the heavens and God gave him some blessing. What should Ben do? So A, invest in the stock market. Diba sa kung isulti, mag-invest mo, no? You should invest wisely. Miss Nelin Ibarat. Okay, good evening, Miss Nelin. We're actually discussing the midterm na yun exam, and you will be discussing this with your classmates so that you will get perfect score. So again, the choices are invest in the stock market and buy his favorite car, because I have mentioned earlier, what are you going to do with your money, hard-earned money? Hard-earned money, you should invest that money, not just kanang put it in a savings bank. So B, pay all his loan obligations since he had to pay a lot of bills pa daw. And then napagid siya mortgage siya yung house and lot. House and lot and car. Then letter C, report the incident to the bank and return the money. Is that the proper thing to do? Or letter D, keep quiet and withdraw the amount without telling anyone about it. So choose among the choices is the correct answer now. Number 13, true or false. The debtor shall have the right to choose those prestations. What are prestations again? Prestations are, could be to give, not to do, which are impossible. Debtor shall have the right to choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. Is this true or is this false? A, true. This is an example of alternative obligations where the debtor has the right to choose the prestations. Or letter B, false. Although the debtor has the right to choose the prestations in alternative obligations, he cannot, however, choose that are impossible, unlawful, blah, blah, blah. So, which among these two is the correct answer for number 13? Let's proceed to number 14. This is an obligation referring to the person who is demanding. That person who is demanding the performance of the obligation. Is it A, obligor or obligee? Check yun ninyo class ha, kani ha. B, obligor or debtor. C, passive subject. Always review the choices. Kay kani siya magtuplok-tuplok ra bata sa Google form. D, active subject. Or E, none of the above. I really suggest class nga mag-online form mo. Why? Balik sa tapos ata. Mag-online form mo, ayaw mo atong printed. If you have classmates who would want to have the printed, ako mag-on na, you have to picture and then upload, and then it will take some time for me to check. Kay kani siya, dili ko masugot nga sa akong email ad i-submit. Now, if you're gonna submit this 8 pages sa ato ang messenger, na tendency nga ma-message request mo. Kaya dito ma-filter siya. If ma-message request mo, it would take time. Kaya na ako'y 200 as of this time. I have 200 message requests. Daghan kayo. And then I have to check pag yun asa mo nga section. And then as you already know, natay Google Classroom nga dito ko. Have you seen your scores? Nakita ninyo yung scores sa Google Classroom na kung i-release?
Yes,
Na dito
Yes,
yung
ma'am.
scores. Yes, na dito yung scores. And then sa inyong scores, makita ninyo
Yes, ma'am.
unsa ang inyong standing. So, dili na mo kailangan mo talis yung classmate. Yun sa ninyo. No. That's the reason why I'm doing this Google form para diretso nako ma-upload, makita ninyo diretso insigida. Plus, as you can see, this is kuha na siya multiple choice para dali. Although medyo lisod-lisod siya gamay, no? Medyo tricky siya. Pero dali rani siya, ma-answeran ninyo. And then you can review, if you missed some questions, you can review your questions. And then, pwede pag yun mo ma-check ninyo. And then you can relate that to your classmates pag yun. Because sa previous na ko nga mga exams, imagine ha katong previous pandemic pag yun, gikuan gid ako sila class, on the spot exam. On the spot akong pag-exam sa ila, and then they were able to make it. Kaya na lang ko sa ila nga, paspason, I gave them, akong gihimo na sila classes, wala na ko ni gidis, wala ko gadiscuss sa ila, ani. Ako silang gipabasa sa libro, na ako'y gamay discussion before kay face to face, and then I gave them a certain time nga Miss Bartolome. I gave them a certain time within which to check na sila preview sa katong module, I mean the midterm nga exam. I gave them only 1 hour. After that, gipalong dahil ako gitanggal. And then nag-discuss na din sila. After sa ilang discussion, exam. So, grabe kay saran. Pag man sila exam, palong na pod. Walay retake, walay kwan. Kung wala ka nakatake, wala pa, bye-bye. Pero may na lang to sila kay naka-take din pod sila kay nauban nagpahulam og load ana bitaw. So kanya-kanyang diskarte na yan. So let's proceed. This is an obligation referring naman na siya no. So 15 to 17. Kuha na po din siya, situational. We have Candy. Candy is an obsessive compulsive. I've already discussed this earlier. This is another kuha na siya example akong gihata ganina. She always sees to it that everything around her are neat and in order. When she saw her neighbor Christian's lawn in disarray and messy, she hired a cleaner and gardener to clean and beautify the lawn without Christian's authority and knowledge. Is Christian obliged to pay Candy for cleaning and beautifying his lawn? Why? So we have here the choices. A. No, cleaning and beautifying Christian's lawn are not necessities within the contemplation of the law. Candy did it on her own without authority from Roman. Dili ni Roman gang, this is Christian. She hired a cleaner and the gardener, therefore she bears the expenses of hiring them. Next, Candy, view all, admit all, sorry. So, nisulti na po siya dire, si Candy daw, sa choice number 2, B, no, Candy did it on her own without authority from Christian. Her obsessive-compulsive disorder and meddling with Christian's property should not be tolerated by the latter. Is that the correct answer? Letter C, yes, Candy should be paid for the services she paid. Christian should be ashamed if he would let it pass without him paying a dime. Char, dime good. So, baba na siya ang proper answer? Or is it letter D? Yes, Candy can recover from Christian even without his authority since he benefited from cleaning and beautifying the lawn. This is under the principle that no one shall enrich himself at the expense of the other. So, which among these choices is the correct answer? A, B, C, or D? Number 18. Which of the following concepts illustrate the case of Candy and Christian? So, balikan niyo mo. Kaning case ni Candy of Christian. What is this? This is civil obligation ba? Neighborhood? Letter C, natural obligation ba? Or D, quasi contract? So, choose lang mo ana sa correct answer. Number 19. Which best exemplifies this case? You have a car note. Kanang car note ha, kanang bitang mga mortgage. Over the next 5 years, once you pay the last payment, at the end of the 5th year, the obligation ends. Is that condonation of condition, consignation of payment, suspensive condition, resolutory condition, or obligatory condition? Nag-discuss na ko ni. Is it A, B, C, D, or E? Number 20. Demand is not necessary to incur delay when? Dili siya necessary to incur delay when? A. Creditor refuses performance. Dili siya ganahan magkuan ka, ma-perform ka, dili siya ganahan. Ni-refuse siya. B. The debtor is guilty of non-performance. Kani siya, non-fulfillment. C. Time is the controlling motive. Not necessary ba siya to incur delay ang demand kung time is the controlling motive? Or D. Obligation bears interest. So, choose among the choices is the correct answer. Number 21. Obligation arises from the following except. Anong type term din class of except. Tanan daw kuno siya sources of obligation except A. Law, contract, constitution, quasi contract, delegates. So, pili lang mo asa dira. 22 to 24. Allison went to Sandra's shop, gave a design, check ha, nihatag siya design, instructed Sandra to sew a dress. As specified in the drawing, kay dito siyang design, she specified how that dress was supposed to be sewn. She told Sandra she will pay 2,500 pesos. Tapos ni, okay po si Sandra, okay, mananahi, okay. The following day, Sandra went to Allison's RTW, kasi hindi si Allison, ano siya, RTW shop. And Sandra gave Allison the dress, and she asked now for payment. When Allison saw the dress, she told Sandra that she already had changed her mind and said that she found another dress much better than Sandra's dress daw. Sandra said she cannot do so since Allison already promised to buy her dress and she sewed the dress based on the specs as Allison told her to do. Now, can Sandra insist Allison to pay for the dress? If so, why? So, we have here the choices. Nandito si Sandra na si Allison. Allison siya tong nagpatahi. Sandra being the dressmaker, ni-agree siya sa specs and then she said, no, sige, I will deliver this one. The following day, she went to Allison, then Allison, ni-refuse na siya. Now, A, no, Sandra cannot insist Allison to pay for the dress. It must be that the dress was poorly sewn. That was why Allison changed her mind. Besides, there was no written contract or proof of their agreement to begin with. Is this the proper answer or the correct answer? Or letter B? Isa man yun. Si Miss Michelle. Okay, letter B. Ano naman to siya? Letter B. So, Miss Deroy, we are actually discussing na the exam. The letter B. No, Sandra cannot insist Allison to pay for the dress. Okay, she cannot insist to pay the dress because Allison has the right of refusal. Nada ko na siya right to refuse. Should the specs fail short as executed by Sandra, there was no contract between the two of them. Letter C. Yes, Sandra can insist Allison to pay for the dress. There was already a contract between them, Nicholas, though verbal. The contract need not be necessary as long as the requisites or elements of contract are present and Allison cannot whimsically change her mind. Is this the correct answer? Or D? Yes, Sandra can insist Allison to pay for the dress. It would be unfair on the part of Sandra since she did her best to sew the dress on such short a time. So, asa diri ang correct nga answer? You discuss this among yourselves. Number 25. It is the juridical relation resulting from lawful, voluntary, and unilateral acts by virtue of which the parties become bound to each other to the end that no one shall be unjustly enriched or benefited at the expense of another. Choose among the following is the correct answer or to be the correct answer. Number 26. What are the essential requisites of contract? Saman to class. Is it A, active subject, passive subject, prestation, juridical tie, or vinculum iure? Kani siya class. Mo ba ni si contract? Letter B, passive subject, active subject, law, meeting of minds, prestation. Mo ba ni si contract? Letter B, meeting of minds, active subject, passive subject, prestation to give something, not to do something. Or letter D, consent, object, subject matter, cause, or consideration. Asa man diri. Essential requisites of contract. Ang contract, dili parihas ni obligation. Timan ina. Number 27. Nagalibog-libog lang anak class. Ayaw mo kalibog kang obligation o ayaw mo kalibog kang contract. It is a mode of extinguishing an obligation when two persons in their own right are creditors of each other. Creditors of each other silang duha. Si creditor, buyer siya, si buyer naging creditor po. So, which of the following is the correct answer? Is it novation, compensation, reformation, or confusion? Asa dira. The number 28. Distinguish contracts from quasi-contracts. 2 points. Mo ni siya. Quasi-contract is a civil obligation and a natural obligation while contract is just a civil obligation. Tama ba yan? Consent is an essential requirement for validity of a contract while in quasi-contract, there is no consent as the same is implied by law. Tama ba yan? Or letter C, consent is an essential requirement for the validity of quasi-contract. Tama ba? As it is implied by law while contract is a meeting of minds of the party. Libong ni siya class. Gamay. So, it is up to you to choose the correct answer kay naa dira class nalay upang mga words dira nga nagpalibog-libog. Number 29, Josefina is Tanya's co-maker in the contract of loan. Tanya defaulted in payment. The creditor ran after Josefina. Is this proper? Tama ba? Nga si Tanya, mo'y nangutang, dayon ang creditor ni adto siya kang Josefina. Tama ba ni? A. No, Tanya is the borrower. Her obligation is patrimonial, meaning private to her and not to other person, not private to the contract. Letter B. Yes, Josefina is Tanya's co-maker, meaning their obligation is solidary. Tama ba na? Yes, Tanya is Josefina's co-maker, meaning their obligation is solidary. Letter D. No, being a mere co-maker, their obligation is only joint. Asa man din ha, ang tama ng answer. Discuss na anak class ha. Dapat perfect mo class para di na mo mag-finals. Kay anak, I thought nga, kaning midterms mo na ni, dili daw, kay mag-finals pa daw mo. Na, mas lisod si finals. Which best exemplifies this case? Your rent is due on the 15th of July. You have an obligation to pay rent. Performance is held in abeyance. Bari, gihold sa ang imong obligasyon on the 15th. Unsa man ni? Is this condonation of condition, consignation of payment, suspensive condition, resolutory condition, or obligatory condition? Hold in abeyance ha ang performance. Hold in abeyance. Unsa man na siya? Is that dere ana. So you choose. Sayo na kay na class. Lessor A leased his apartment unit to lessee B. Ang lessee ha, mo ni siya nirenta. Si lessor si A. In the contract of lease, it was stipulated therein that for failure of lessee B, si B, wala siya nakabaya siyang rentals for 2 consecutive months. Si A daw kuno, nana sa ilang kontrata ha. Si A daw kuno, may validly eject B. By ejection, pahawaon niya si B. Nga dili na sila kailangan matukorte. Upon B's failure to pay the 2 monthly rentals, he was ejected jud from the premises. Now B goes to court. Ana siya, hala mo to ko sa korte, oy, unfair kis tanan. Na siya dito, dapat magkorte-korte gid mi. Goes to court for damages for his alleged failure to exercise his day in court. Ingon siya, wala due process. I must be heard. I must have my day in court. Ana siya. Now, is this proper? You decide. A. B's contention is valid because the contract between them vests reciprocal. Ang reciprocal is na obligasyon. Ang isa na po siya obligasyon. Si creditor na siya obligasyon. Si debtor na po siya obligasyon. So kani si lessor na siya obligasyon kang lessee, si lessee na po siya obligasyon kang lessor. Is that it? Hence, he must have his right to seek judicial recourse. Dapat daw nga nagit siya day in court. Mao nang gisulti ni A. Si B, ingon ni B, ni letter B, B's contention is valid. Yun niya, kailangan di siya na day in court because it must be proved that he indeed failed. Kailangan pa i-prove sa court that he failed to pay the 2 months nga rental. C. A's action is right because the injured party has the right to rescind. Ingon niya nga, si A naman siya right to rescind. Yan ang matanggal na, palong na ang obligation sa contract. Letter D. A's action is correct because A's non-resort to judicial action is expressed in the contract daw. Kaya nakasulat daw kuno sa contract, therefore, ilan na nang himuon. Now, what is contract again? Meeting of minds between the two people. Then I have already asked before earlier, if the contract is notarized, is it valid? Nagsulti, ni Ms. Luisita nga, dili daw kuno, but I corrected her. I said na it need not be notarized as long as it is the contract, the stipulations in the contract are actually the agreement of the party, then the contract is valid. So, mao ba na siya? Letter E. B's contention is correct because in all reciprocal obligations, the right of the parties to rescind the contract is implied. Kanidang right sa parties to rescind or wala ng contract, implied daw kuno. And that kailangan ang court daw mo decide. Ang mo decide daw siya, mo check daw siya kung tinud ba yun nga. Nagid sila right to rescind. So, choose among the choices the correct answer. Juana sold a one of a kind. Meaning to say one of a kind kay special edition gini siya. Wala gid siya katulad ng iisang laptop to Josie through Shopee. Now, Josie paid the laptop through her credit card. While in transit, balikamulo pa lang, ipadala to yung laptop, special edition. Katong rider ni Juana was supposed to deliver their laptop na narab siya. He was robbed and killed pag yun. Thus, the laptop did not reach Josie. Juana called Josie and told her about the incident. Hala, narab akong driver pa, tapos namatay pa Jun. And then Josie called her bank. Si Josie, di ba, credit card. She called her bank to cancel the charging of payment through her credit card. Notwithstanding this turn of events, balag i-cancel na niya yung credit card, niingon pagi si Josie nga, hoy, i-deliver sa ako tong same laptop. Maybe she decided siguro to kuan COD pero wala butang diri. She demanded the delivery of the same laptop, special edition, one of a kind, nag-iisa. Now, mag-decide tabi, letter A. Juana should deliver the same kind and value of laptop to Josie because she is still obliged to deliver the thing which is generic. Generic ba to siya nga edition laptop? Letter B. Juana is no longer liable. Dili na daw siya liable to deliver the same laptop since what happened was a fortuitous event daw kuno and beyond their powers. Furthermore, it was a special edition laptop which is already out of commerce. Ingon niya. And then C. Juana haplessly is still liable to deliver the same laptop to Josie. She should, however, file a criminal case pag yun. Na. Letter D. Juana's obligation is not totally extinguished. Since the incident could not fall under fortuitous event, Juana bears the risk of loss since there was still no delivery to Josie. Now, kani siya, naku, wala diri class ha. Kato sabot sa fortuitous event. Now, this is supposed to be force majeure. Anyway, it's up to you to decide A, B, C, or D. 37 to 38. On December 20, 2020, William binds himself to pay Jacob the amount of 20,000. 3 days after, Jacob went to William's house and he asked him to pay the 20,000. Imagine ha, on December 2020, ingon ni William, bayaran tika og 20,000. Pagka December 21, 22, 23, si Jacob, niyato siya kang William, ingon sa bayari ko, ay kuan ka ng bayari ko atong 20,000. Since he needed the cash to buy medicine for his sister. Tapos, ingon ni William, ay dili pwede, sayo pa kayo. Sayo pa kayo nga magbayad ko sa imo 20,000. Jacob, on the other hand, insisted and demanded at once. Again, on December 2020, si William, yang ingon, siyang gibayan niyang kaugalingon, sige, bayaran ti ka Jacob og 20,000. December 2020 yon, ha. Pagka 3 days, saka pa niadto si Jacob kang William nga magbayaran na siya dapat og 20,000. Now, pwede ba nga si Jacob maka-insist siya nga bayaran siya at once? A. William is right. Jacob cannot demand said sum just 3 days after William borrowed the amount. Ingon siya, demand payment must be done during convenient times. So, pag musuti ka during convenient times lugar, convenient times sa obligor lugar. Letter B. Jacob is right. He can demand payment at once. This is an example of pure obligation. Ano sa itong isuti sa pure obligation? Just remember that. Letter C. Jacob is right. He can demand payment at once since time is of the essence and he needed the amount for his sister's medical needs. Kuno. Letter D. Both of them have reasons, but William's reason is correct. How can he pay when he just borrowed the amount 3 days ago? And then, letter E. This is a difficult case. Both of them should go to court to resolve their concern. So, may answer na to. 39. Which among the following may not be an underlying philosophy and obligations arising from contracts? How many ganito? One gani sources? Basically, we have two main sources gyud ha, katong law o contracts. Katong sa law, katong delicts, quasi-delicts, o katong sa quasi contracts o law. Kato sila, puro to sila mga sa law, ha? Kato sila, katong tulo, quasi-contracts, quasi-delicts of delicts, plus law. Of course, law to sila. Ang contract, separate na siya, kaya agreement na siya sa parties. So, which among the following may not be the underlying philosophy sa obligation? Not an underlying philosophy. A, good faith. B, freedom to contract. C, law between the parties. Or D, reciprocity. Asa man dira? Dili siya underlying philosophy. Number 40, this obligation is characterized by being immediately due and by lack of burden of time or condition. Asa man dire? Simple obligation, immediately due klasa. Unsa to? Immediately due, demandable at once. Unsa man na siya? Simple obligation, obligation with penalty, pure obligation, or conditional obligation. Asa din ha. Number 41. In an obligation whereby the obligor is bound by different prestations, A. It is the debtor who has the right of choice unless the creditor is given that right ko, no? Letter B. Bound by different prestations. Sa lain-lain, pwede siya dito to give or na siya alternative. Na, pwede na lang, ngayon na lang tong himuon na lang or insa ba na siya ang klase ng prestation. Letter B. The right of choice to the debtor gives him freedom to choose daw kuno. Or letter C. The debtor can choose to give a portion, or part of each prestations except those which are indivisible. Katong dili niya ma-divide. Dili niya ma-divide. O, asa man dira ang tamang answer. Number 42, hapit at the class. Emma entered into a contract of loan with Jane. Ano po di si Jane? Under that contract, Jane lent Emma 50,000 which was due on March 25, 2020. Now on March 5, 2020, Erica told Jane that she would pay for Emma. Okay? She would pay for Emma on March 25 since she knew Emma had no money at that time. So she told Jane that Emma even borrowed 25,000 from her. So kani lugar si Emma, di ba? Na siya loan kan Jane. Tapos si Jane yung ipaulam. Then later si Erica, lain siya tao. She told Jane that she would pay Emma for March 2025. Kabalo siya si Emma, walay kwarta. She told Jane that Emma even borrowed 25k from her that day. Jane agreed but on the condition that Erica, ingon siya, sige. Ano siya? Pero kailangan nga, kuhaon mo ang consent ni Emma. Ano siya? Which she did secure that day. On March 25, March 5 man to nag-istorya si Erica kuno no. Na daw kuno kuan. Bayaran daw niya si Emma kanana. On March 25, 2020, Jane went to Erica. Ingon niya, sige, bayarin ako. Ano siya tong 50k. Nya, wala man siya bayarin ni Erica. Can Jane demand payment from Emma? Why? So, natin choices. Pili lang mo. Ana la siya daan. Okay. Then, the following are the consequences of solidarity. Ako ni balik class sa diri na. Asa diri, katong kang Erica kang Jane. Balikan ninyo class, basahan ninyo tarong. Alas 8 na di ay. Number 43, the following are the consequences of solidarity. Solidarity, except. Narapot si word nga, except. Full payment made by any one of the solidary debtors extinguishes the obligation. Full payment made by one of the solidary debtors, mawala daw kuno obligation. B. The one who paid can claim reimbursement from his co-debtors as regards their corresponding shares in the obligation. Letter C. Full payment to any of the creditors extinguishes the obligation. Letter D. The one who fully paid the amount shall be reimbursed for the amount he paid, and the co-debtors should pay in equal shares based on the total amount paid by the former. So, asa man diri? E, A and B only, F, A and B and C, G, all of the above, or kanisa A, B, C, D. Choose. Which of the following is the consequence of joint obligation? Each creditor shall be entitled to the credit. Each creditor shall be entitled to the loan amount. Each debtor shall be liable for a proportionate part of the entire debt. Or D, any of the debtors shall be liable to pay the entire loan amount considering that their obligation is joint. Mao daw kuno ba na? So A, B, C, and D. 45, true or false? Acceptance must be made during the lifetime of the donor and donee. Basahan niyo dito sa atong module class. So, in this case, true. This is for the donee to immediately accept the donation daw kuno. Acceptance must be made during the lifetime of the donor o the donee. Okay, kung halimbawa, i-accept na nimo, namatay na si donor, pwede ba yun? Mao ba na siya? So, false. Donation can be made even after the lifetime, after do kuno namatay na si donee, since rights can be thus transmitted daw to compulsory heirs daw kuno. Example, ani, ako, ang donee, akong gihatagan. So, kato namatay lugar ko, namatay ko, then akong mga anak, sila naman daw kuno ang makakuha na daw kuno sa donation daw kuno. So donation can be made after my lifetime kuno. Balag patay na ko. Is that correct? True. This is to avoid any confusion on transmissibility of rights. Resulti diri, acceptance must be made during the lifetime of the donee and the donor. Mao na siya. True, to avoid confusion on transmissibility of rights, and at the same time, since a donation is deemed a burden on the part of the donee, ano man, kay burden na siya sa part sa donee, ma'am, kay naman ko ubang donation, no, bayad pa kaw tax, which is true, magbayad pa ka sa tax, ang uban niya kuan ani imo pag yung ayuson, dili lang basta-basta imong paningkamuton. So is this the correct answer? Or false? Acceptance can be made anytime since this is gratuitous. Hence, it could be during or after the lifetime of either the donee or the donor. So, ang kaning A, B, ano siya, A, B, C, and D, hati klasa. A, B, C, or D. Number 46, last yun siya, MCQ. Mode of extinguishing obligation which is subject to condition, the fulfillment of which extinguishes the obligation. Condition, fulfillment of such condition extinguishes the obligation. Asa man the renovation, compensation, expiration, fulfillment of specific condition, or compromise. A, B, C, D, or E. Ha? So, activity 2, essay questions. Ayun na kay class, piyong-piyongan na ninyo. Ayaw lang mo pag-answer of all capital letters, tapos small letters, tapos walay period, tapos na hyphen. When you answer essay questions class, sentence form na siya, paragraph form. Ina ang pag-answer sa essay. So when I ask, what are the essential requisites of contract? Just give me in sentence form, what are the essential requisites of contract? So you say, the essential requisites of contract are blah 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 blah, comma, blah blah, comma, blah blah, comma, period. Inanaro na siya ka. Dili nga 1, 2, 3, 4, 5, 6. No, dili na. Inyo na siyang i-sentence form. Essay number 2. Why are active subject, passive subject, prestation, and vinculum jury called essential elements or requisites of obligation? Nga naman nga kato silang upat, kani silang upat, gitawag sila nga essential elements or requisites of obligation. In sentence form gyapon, mubua ayaw pag hyphen, do capitalization of letters tanan. So inyo lang i-capital is the first letter of the sentence lang. Okay ba? So that would be the end of your midterm exam. I hope that you will discuss among yourselves the correct answer so that you will have perfect scores then, and then you will be exempted sa final exams. As to those persons or students who submitted via Google Classroom their recommendations or suggestions, even if wala mo nakuha sa 5, I will give points gihapon. So I will give 2 points each of those students sa ilang midterm scores. Katong mga nag-submit lang ha. Katong wala nag-submit, syempre wala. Then I will also add points po yun kay Miss Agasita. Si Miss Agasita rato na answer ba? Si Miss Agasita po. So, do you have other questions? Violent reactions? Go, comment. Isa man. Pangutan na class. Mao to siyang exam. That would be your exam. And then, gusto na ko nga mahuman ninyo within 2 hours. For example, kaya makita mo na ko na, naka-timestamp 10 class, makita na ko nga ni 2 hours mo. Kung more than 2 hours mo, deduction mo. Okay? So, halimbawa, nag-open mo 7 o'clock. Kaya ako naman ang i-open dayon at 6. 7 o'clock. Pag abot sa 7 o'clock, nahuman mo kay katong end man is 10. Pag kuha ninyo 3 hours mo, instead nga 2 hours, 2 hours naman in good class. 2 hours mo, deduction mo 2 points. Within 2 hours ra gyud. Mugawas man na sa timestamp ninyo. Inani maguna siya klaso, kalang ha. I will show you ha. Ma-count ko na siya. Inani akong pag kuan sa Google form ninyo. Para makita ninyo unsa na siya. Ngano makasuti man ka ma'am nga may timestamp. Nga sa kadali. Para ma-aware mo class nga kani siya is inani maguna siya. All exams should be time constraint na siya. Ngano man ma'am, mag-time constraint ta kay para ma-aware mo sa inyong pag-answer. Kay kung dili ta mag-time constraint, magdili-dali mo. Kung magdili-dali mo, madala na ninyo hantod sa wata kabalo, basin maglomo or magpadayon mo og accountancy, magkuan mo. Ano ni siya, ikuan ako ni siyang sa exam to Google. Yeah. Nakita ninyo? Ano ba nakita class? I'm presenting what? Nakita ninyo ning kuan? Wala pa day. Ako sa ning palungon ha. Wala pa no. Stop presenting. Okay, ako na siyang i-present sa inyo ang kaning tab. Kani type nga responses. For example, sa BSBA 2B, nani siya itsura. Pag answer ninyo, naka-timestamp yan. Ayan yan, no? Timestamp, oh. So, kung magkuhan na ninyo, medyo manikas ta gamay. Makita gyapon na masampulan gyapon ta mo. So nadira inyong mga answers, makita na ko na sila po. Ayan. So dili mo makasulti nga ma'am, ako mga answer kuan ma'am, ako inan. Naman tay basihan ani. So mo na siya class nga 2 hours ra gyud ta class. Okay? So before mo answer, maggrupo mo. Ang gihimo sa ako ang mga kuan sa mga estudyante before was, yun ang gihimo. Kay gakuan gyud na sila, kanang bitang nga grupo sila. Di ba? Nakuha na ako ni sa akong YouTube, no? Dito sa YouTube. So once pag adto dito sa YouTube, ilan ang i-kuan? May nalagani mo kay napa ni YouTube, no? Ilan ang i-check tanan-tanan kani unsa man yung answer ani. Then check the modules, discuss. Na ako'y gipanghatag nga hints actually nga mao to siyang answer kung naminaw jud mo na dito gyatag nako ang hints asa ni saka akong tingog, asa ni pause, yun. So, kana siya, pag-discuss ninyo, and then mag-answer na mo, by group yan. By grupo kayo. So, as much as possible, makuha yun ninyo ang tama yun nga answer, kay no more retakes. So, tika, ma'am, gamay kista na nga akong score, ma'am. No, wala gyud ko'y mahimo. Kay gihatagan na mo chance. Okay? Sa module, naara dito sa module. Kita mo anang mga kuan, mga lamp, light. Mo na siya gyud pinaka-kuan gyud na kanang na mga light, na mga pin, halos tanan naman po'y pin, no? Pero kuan siya, tanawalan niyo balik ang kanang kuan dira sa inyong midterm exam mismo. So, if you have questions, pwede man po na ninyo ma-raise. We still have time, kaya that will be next week para ma-discuss na to. Hatagan ta mo balik og hints. Okay? You have questions?
Ma'am, sorry to interrupt. Ma'am, when would be the exam?
The exam would be next week, 28. I think 28 akong yata. 28? 28 ba to? Yeah, 28. 28
That would be morning, ma'am.
No. Ang exam is evening up to 10 p.m. So,
Okay.
up to 10 p.m. So, for example, nag-open mo, kay 6 man ko mag-open ana. So, for example, 6. So, you will have 6 o'clock to 8. 2 hours. Kung 7 ka nag-open, 7 to 9, 2 hours. Kung ikaw, 8 to 10, 2 hours. Basta by 10, saradon ko na. Palungon ko ng responses, di na ko madawat.
Thank you po.
Pag halimbawa, naiuban nga masulti, kung daghan man mo, magsulti nga, ma'am, pwede ma'am nga morning, then I will open that morning. Pero ang pinaka-early yun sa morning is 10 a.m. I-open ako na, pero if 10 a.m. ka mag-start, 12 noon. Mugawas na sa timestamp. Hindi punta ka ilad. Muna siya, class. So, do you have other questions? Violent reactions? Sa'yo na, class. Uy! Sa'yo na kay midterms, class. Sa'yo na kay stanan. Ma-perfect lagi na ninyo. O, ban gani? Naka-perfect gani. Kamu pa. Gidiscuss pa na ko ni. Diba? So, kinsa man tong maka-perfect? Exempted sa finals. Tapos, for example, sa inyo, no, inyong score, halimbawa, kay di ba, 100 points man, that's 100%. So, for example, imong points, 98, tapos, isa ka sa mga nag-submit o recommendation or suggestion, so, plus 2, 100 ka, exempted ka. Same po kay Miss Agasita, halimbawa, nag-submit siya, plus nakatubag siya karon, so, 4 points, di ba? 96 siya, plus 4, 100 exempted siya. Nanana class. Ha? Questions? Violent reactions? Wala? Napa ba ning mabata? Napa bang? Oh, yun siya. So, I hope na kamo class is makakuan gid mo. Some of your classmates were not able to make it na nag-message na wala daw sila kakuan. Ayaw lagi mo pag message lagi class nga individually, private message, direct message kay dili na ko na makita dayon diretso. Akong anak ang nagreklamo kay naday. Kuan na siya class kana bitang sa chat lang, please make it sa atong GC sa atong group chat so that I can see it, and also your classmates would be able to check on your messages too, and your comments para na po sila masulti po yung impact. Because I really want you guys to discuss, not just scene zone, scene mode. Kaya ang gusto na ko sa inyo is you really have to talk. We cannot have the face-to-face interaction. This is the only way that I would know nga at least na may nakuha. Because we cannot study nga dili wala may mahibaw-an because 'di ba mag third year na dayon mo, then fourth year. After that, mo graduate na mo puhon-puhon. I want you guys that when you graduate, you learn a lot from your subject sa inyong mga instructors. Dili pwede nga nag-activity rami, nag-module rami, wala kami nahibuan. Di na siya maayo. Okay, what is the essence of learning? Di ba? Kung nga nung nag-eskwela pa man ta, pwede man siguro nga, ipag-graduate na lang mo, diretso. Wala po challenge o pag mo trabaho mo versus another student, another graduate from another university, lisod kayo mo kuwaon. Di ba? So, ato ipakita po nga mas maayo mo kaysa ila. Being the scholar ng bayan. Okay? So, do you have other questions before we finally end our online discussion?
None so far, ma'am. Maybe we can refer it sa GC na, ma'am, if any further questions, ma'am.
Yes, okay. Thank you very much. So, class, thank you very much for your time. Ladies and gentlemen, we have just finished our online discussion for the midterm coverage of our business law with my able and very active though, students from Bukidnon State University, Alubihid Satellite School, as well as Baungon Satellite School. If you have comments for those viewers who are not students of mine, you can comment down below or you can send your comments via my email. That's attyhoneyxyz@gmail.com. Thank you very much for watching. I hope that you learned from this exercise or online discussion. Thank you very much. Good
Thank
day.
you so much,
God
ma'am.
bless. Arigatou gozaimasu. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, ma'am.
Thank you.
Thank
Goodbye.
you po.
Goodbye.
God bless po.